side mentioning listed matter item number 1 for judgment, Godrej and Boys Manufacturing Company Limited versus Shapurji Palonji.
Hence, in the facts of the instant case, instead of relegating the parties to a fresh invocation and necessitating a de novo application under Section 11, the most expeditious and prudent course of action would be to entertain the present application by turning down the objection as to maintainability and to refer the dispute to arbitration. In such view of the matter, AP number such and such is allowed, appointing Mr. Devashish Rai, an advocate practicing in this court and a member of the Bar Association, room number 2, as the sole arbitrator to resolve the dispute between the parties arising out of the 3 purchase orders in dispute in a consolidated manner, subject to obtaining his consent declaration. But you argued very well, Mr. Vishwas. I'm sorry that your client lost.
I'm very humble, your Lord.
But I was in a dilemma in this.
Grateful.
Thank you.
Lordship, due to very urgency, I'm praying for leave to list and hear this matter because Lordship, Electricity Authority connect high voltage electric connection to adjacent to the house of the petitioner and also 100 residential villagers.
It can only appear in the list on Monday. It can only appear on Monday, not before that. Today it cannot be. So please come at 2 p.m. or send somebody at 2 p.m. when the appellate side matter, or wait for some time. I'll take up the original side matters, then take up the appellate side, then mention. Thank you. This is appellate side.
Appellate side.
Please wait for some time. Just
New motions, item number 2, Golam Kibriya versus ITI Limited.
Please, your Lordship, my Lord.
Before my learned friend, my Lord, starts, my Lord, I appear for the respondent, my Lord, 2 to, my Lord, 5, my Lord, 2 to 5. Copy has been served, my Lord, I appear for the respondent, I have instruction to appear for the respondent. My Lord, it has been sent to Bangalore office, our Calcutta office did not receive. Even, my Lord, the Bangalore office has only received, my Lord,
Only on yesterday, I was going to say that.
Without, my Lord, any annexure.
No.
So,
I have given that with annexure, but they have received it only yesterday. I was supposed to say that because affidavit of service is not ready, we will file it.
I'll keep it on Monday then.
Monday.
Give a complete copy. Ask your learned junior to give a complete. I'm not recording that. A complete copy has not been given of these things. Yes, difficulty. On the prayer of learned counsel for the respondent, the matter is adjourned till
Can it be on Tuesday?
In May 16, 2023. First up, the petitioners shall file an affidavit of service on the next returnable date.
Lot.
All the 4 matters.
All the 4 matters.
2 to 5.
2 to 5 are the same.
2 to 5, right?
Same matters.
আলাদা আলাদা করেই অর্ডার কেন কনসলিডেটেড করে কিনা এখনো জানি না।
Grateful.
Thank you.
Item number 6.
Yes.
Khagra Joydev Resources Private Limited versus Damodar Valley Corporation.
Please, your Lordship.
Yes, Mr. Wag.
My Lord, this is an application for
I'm appearing for the respondent.
appointment of an arbitrator, my Lord.
Are you objecting? First, let me clarify that. If you're not, then I'll just appoint.
No, my Lord,
Not serious.
pursuant to this arbitrations clause, my Lord, the requirement was to, my Lord, initiate a mediation process, my Lord, settlement process. If it fails, then arbitrator will be appointed.
It has
I
been
find that the settlement has failed.
Thank you so much for your fairness. So, what is the value of the dispute?
my Lord, it is around 25 crores, my Lord. May I indicate the
Exact.
arbitration clause, my Lord? It's at page 21. Clause 18, my Lord. This is not disputed.
What is the dispute? Just indicate money.
My Lord, essentially a money claim. Work order issued, but work not carried out. Money work carried out, money not
Should
given.
I appoint an ex-Supreme Court judge in this matter or ex-High Court judge?
My lord, subject to my no consent may be recorded, my lord. I have talked to Mr.
No,
Tarawal, my lord.
no, my Lord, I leave it to your Lordship, my Lord, as your Lordship fit. my
Who
Lord.
is the consensus?
Justice Subro Kamal Mukherjee.
I'm told, my Lord, there's a
But no
separate.
consent should be recorded. Mr. Tarawal,
Unless it is the consent is recorded, I won't.
one arbitration is still going on.
Before
My Lord, I'm told DVC arbitration is, my Lord, going on before him. And
My Lord,
DVC is
I
not-
leave it to your Lordship, my Lord.
Since the rules are common,
No consent should be recorded.
In principle, comma, the respondent does not object to arbitration. Full stop. Next para. However, comma, the merits of the dispute are denied by the respondent. Full stop. Next para.
Value is high
The
to Supreme
dispute
Court.
arising between the parties.
My lord, value is high, my lord. Any Supreme Court judge, my lord, may be appointed because value is too high, my lord.
Value is very high.
Or I leave it to your lordship.
The venue is Calcutta as per the arbitration.
The venue is Calcutta, definitely, but
Yes.
two of the judges are operating as arbiters, Justice Indira Banerjee and Justice
Ha.
Ashokam.
Ha.
So I'll appoint Justice Banerjee then.
Yes.
Good. The dispute arising between the parties is otherwise arbitrable and falls within the purview of clause 18 of the agreement between the parties, comma, which is the arbitration clause. Full stop. Next para. In such view of the matter, comma, AP 275 of 2023 is allowed, comma, thereby appointing Justice Indira Banerjee, a former judge of the Supreme Court, as the sole arbitrator to resolve the dispute between the parties, subject to obtaining her consent stroke declaration under Section 12 of the Arbitration and Conciliation Act 1996.
I'm deeply
Agreed,
obliged,
my
my lord.
Yes. আজকে দুটোই লিস্ট বার করা যাবে? ও যদি এখন মেনশন করে যে লিভ দি দুটো তাহলে একটা টার্ন লিস্ট তাহলে লিবার্টি দিয়ে দেবো, লিস্ট করি তাহলে করে দেবো। ঠিক আছে, লিভ দিয়ে দিচ্ছি, আর্জেন্সি আছে বলছে, এটা ম্যানেজ করতে উনি পারবেন কিনা। মেনশন, ইয়েস,
Lordship,
appellate side.
Lordship, I am praying for leave, Lordship. To
Is it so urgent? Can you move it at 2 p.m? Can you arrange for that?
Lordship,
The other side won't be knowing.
I will serve in the meantime, Lordship.
Before 2,
Before 2, Lordship.
where leave is granted to move the matter at 2. Have it filed, leave take to দিয়ে দিন, এটা ফাইল করে দুটোর সময় একটা সাপ্লিমেন্টারি লিস্ট বার করে রেখে দিন। Please inform your other side. Who is appearing for the other side?
Lordship, this is a new electric connection matter, Lordship.
Oh, WBSCDCL or
WBC.
you can inform Mr. Mukherjee also. He generally appears. Mr. Devjit Mukherjee. Or Dr. Shari is also there. Anyway. Who is junior among you two? You are junior. So Mr. Devjit Mukherjee.
Item number 1, appellate side matter, item number 1.
Yes.
My lord, I appear for the petitioner. I've served, my lord, but the affidavit of service is being affirmed, my lord.
Can you file it during the course of the day?
My lord, I can file.
Private respondent?
Private respondent is there,
Oh, then wait for Monday.
then my lord, not today.
No, do you know whether what is the fate of service on the private respondent?
No, my lord, there is no fate of service on the private respondent.
You're opposing on some-
Yes, his presence is absolutely necessary. Your
Oh.
lordship will kindly,
Keep it on Monday. Keep it on Monday.
because there is a specific direction based on the same cause of action, lordship.
Definitely. On the prayer of learned counsel for the petitioner, the matter is adjourned for the day and shall next be listed on May 15, 2020.
Can it be on 16th?
No, 16th I have some difficulty.
Let it be on 15th. Let us see. Yes.
My lord, my lord.
পরেরটা রাখুন।
Item number 2,
Yes.
I am for the petitioner. Well, the private respondent is the landlord of petitioner. He is the father of the petitioner.
Then I
So,
will-
so only dispute is this, I am the owner of the house, so you have to
Mr.
take.
Halder, what I'll do, because I've suddenly taken up the appellate side matters, people may not be, I'll call up to 8 the motions and then pass it over. এটা pass over রইলো first call. 8 পর্যন্ত ডেকে তারপর আবার এগুলো pass over. Passed over in the first call.
item number 3,
That I'm appearing for CSC in this matter.
Yes, but none is appearing for the petitioner. Mr. Lala, I'm passing over in the first call. After
Mr.
item 8, I'll be taking the second.
Well, Mr. Haldar Senior is here as a lot.
Haldar is there. Oh, Mr. Haldar is here. Yes. He was trying to hide but could not. Yes.
This is the
Kiran sir,
matter where the billing dispute is there. So
That Lok Adalat.
I'm preferring, it can be settled the dispute.
No, if the CSC does not, because they are
CSC
specifically,
has no, I think.
they are taking 2 points. One is that you have not
My lord,
taken any
let
steps. You are
it be
trying to
tried
bypass.
to the Lokadar. If not, it will come back to the court again, my lord. I think it will be easier.
Well, this is the submission I had made yesterday also. I can understand the financial aspect of the matter, but as far as the legal propriety is concerned, well, I think that has to take precedence. Section 127 will stare at Mr. Haldar's face straight away. And even if it goes to Lok Adalat, the Lok Adalat has got no authority to really override the law. So if the 127 says that he has to make a full payment within 30 days, so be it.
Then Mr. Lal, I'll give them liberty to file section 127. What is the limitation? What is the time?
That is.
I mean, what is the delay?
30 days.
Yeah, what is the delay?
Days.
What is the delay in this case? About?
He has filed the writ petition on the 2nd of May.
Right.
And the final order of assessment has been passed on 10th of March.
Oh,
As your lordship, I have no difficulty.
I'll give you that liberty to go under. Act order record. Learned counsel for the petitioner seeks a reference to the Lok Adalat for the purpose of resolution of the dispute amicably. Full stop next para. However, learned counsel for the CSC Limited reiterates his submission of the previous day to the effect that in order to bypass the remedy under section 127 of the Electricity Act 2003, particularly to avoid the time bar stipulated therein, the petitioner is seeking to move the matter before this court and seeks a reference to the Lok Adalat. Full stop next para. It prima facie appears from the dispute herein that the same pertains to a final order of assessment raised by the CSC authorities under section 126 of the Electricity Act 2003. Full stop. Since a specific remedy of appeal has been provided under section 127 of the said act, this court chooses not to interfere with the impugned order. Full stop. As such, there is no question of referring the matter to the Lok Adalat at this stage. Full stop. However, WPA 11070 of 2022 is disposed of by granting liberty to the petitioners to prefer an appeal against section 127 of the 2003 Act to the appellate authority within a week from date. Full stop. If such appeal is preferred within a week from date, the appellate authority shall consider the delay of a few days sympathetically. Full stop. No address to cause urgency. Yes, Mr. Lal.
I'm grateful. Your lordship is very sympathetic towards Mr. Haldar.
Challenge is being preferred, Mr. Lal. Everybody, apart from the advocates also. I mean,
I have no dispute. I'm grateful.
Item number 4, yes.
Item number.
I'm for the state.
Yes.
But I'm for the WACTCL.
Move the matter.
But
Who is for the petitioner?
the prayer is that as he has acquittal under 135, therefore he don't required to pay the money. Now I have covered by a lordship judgment, which is also reported now.
No, but I'll pass over in the first call. Let the petitioner come. Pass over after item 8. I'll be calling the second. Yes. Next.
He's here. She's here.
Item number pass over.
Pass over in the first call. Yes.
Item number 5.
5.
I beg to appear on behalf of the private respondent, but till today I did not get the copy. Copy got through my WhatsApp, but I need physical copy. Can I take it up on Monday?
My lord, kindly then carry it to Wednesday.
Wednesday.
Wednesday, my lord.
Wednesday.
Very well. On the prayer of learned counsel for the parties, the matter is adjourned till May 17, 2023.
Get.
Item number 6.
Pass over in the first call.
Item number 7.
Say.
Item number 7.
Same.
My lord, in this matter, I am appearing on behalf of the petitioner. Another writ petition I have filed, which is solely connected with this instant writ
That's also
petition.
an electricity matter.
Yes, yes, my lord.
Give the number, it will appear together.
Together on Monday.
Please give on a slip of paper. Just give the number.
Yes, my lord, I am giving the slip.
What is the number? Just tell me.
Writ petition number?
The other one, yes.
I have to recollect it.
Very well. Learned counsel.
I am giving it.
Right now. Learned counsel for the petitioner submits that a connected writ petition is also pending relating to a similar issue. First up, the learned advocate on record for the petitioner is requested to furnish the number of the same to enable the said writ petition to be tagged along with the present writ petition and be listed together on May 15, 2023. Monday, এটার সঙ্গে ওটা দিয়ে দেবে। যদি না পরে থাকবে না মানে কারণ তুমি আমি চেঁচামেচি করলে তুমি আমাকে বুঝিয়ে দেবে। আমি চেঁচামেচি করি যদি মানডেতে কেন নেই করে তখন তুমি বলে দেবে আমার যে এই কারণে নেই। এবার 8 হয়ে গেল, হ্যাঁ পাস হবে।
Lordship.
Yes. What is the matter, Mr. Haldar?
My lord, this is the objection of petitioner father. Same property we have served. Same premises, petitioner and the father is staying, and it has been returned back as endorsement, not insufficient address. So, my lord,
Achha, you have to disclose the nature of the objection.
Objection I have disclosed, my lord, I am the owner of the house, so you have to take connection from me. That is the only grievance. My lord,
Any suit pending between you?
No suit is pending, and give direction to give supply. If any objection, then police. If.
Yes.
In this matter, I have been told that Srimoy Mitra is appearing, but
Mr. Haldar, you are sure you are not colluding with your father?
we need to hold an inspection, as I've been told, my lordship.
You are sure you are not colluding with your father?
No.
My inspection is
No suit pending between you.
Nothing.
You should have filed a suit and come. At least some court fees would have been paid there. It's patently collusion to avoid splitting
saving.
up.
Yes.
Anyway,
My inspection is required, lordship.
very well. It is submitted by learned counsel for the CSC Limited that an inspection is required to ascertain the feasibility of giving a separate electricity connection to the petitioner at the at the premises in question. Full stop. Accordingly, the CSC Limited shall hold an inspection. No, you have to give a copy to the other side, the respondents. Hold an inspection. Can you do it by 17th?
Lordship.
Thank you. By June 17, 2023.
May, lordship.
I'm sorry, May 17, 2023. Full stop. A prior notice shall be given to the petitioner as well as the respondent regarding the date and time of such inspection. Full stop. A report in that regard shall be filed on May 18, 2023 when the matter is next listed. Please give an advance copy if possible if somebody appears for them. Mr. Haldar.
Lordship.
Matter will appear
18th. When the matter will be written.
Passover matter, item number 4.
I'm for the statement.
Yes. What is the matter about Mr. Mukherjee? You are for the WBACTC.
But the petitioner has been acquitted.
Mr. Panda, please take your seat. I mean, yes.
But petitioner has been acquitted in 130.
Oh, that is the ground.
135 proceedings. Therefore, he says that reconnection, but 2016 final order was passed. No appeal preferred. Only 50% in terms of the condition for granting bail. Number, I'm covered by your lordship's judgment. If you
No, you are not covered by mine. Their
Yes.
facts are different.
absolutely, my lord, same fact. But this is the only point consideration. before-
Names were same. How can it be absolutely same facts?
But the
Yes, what is your case?
point of law.
Item number 4.
I think it is, yes, item number 4.
Can it be, my lord, pass over for 5 minutes, my lord?
No, it has been passed over for 10 minutes already. So move your matter, please.
My lord, the petitioner was, my lord, convicted under.
Are you without your brief?
Yes, my lord.
She has tried her best. I'll take it up on Monday, Mr.
Yes, my lord. Grateful, my lord.
On the prayer of the petitioner, the matter is adjourned and shall next be listed on May 15, 2023. You have
Grateful,
tried,
my
that is sufficient. Thank
Grateful,
you.
my lord.
Come back on Monday. Yes. Next.
Possible matter item number 6.
6. 6 of the
I'm for the CSC. CUNY.
None appears for the petitioner even on the second call. Let the matter stand adjourned for the day.
Possible matter item number 7.
But I am for the CSC, madam. A legible copy is required because the copy which has been served not legible.
None, same order. None appears for the petitioner adjourned till. Please give a letter to your counterpart who is appearing for the petition.
Another CSC.
Item number 9. Item number 9.
Your Lordship, on the last occasion, there was
But
an
I am for
order,
the petitioner, my lord.
there was an order for filing of a composite of affidavits, opposition. Now, that was supposed to be served us on us by 18th, which was served to us on around 26th.
What was served on you?
The supplementary affidavit and the writ petition also, because there was an order to serve me on the writ petition also. Because it's a very old matter.
What is the crux of your prayer?
Now, the only thing is that I'm serving them the copy of opposition now. It's ready. I will serve it on the file with the court on the next occasion, because your Lordship, that is on transit from Bilaspur. That's all.
So till when should I give you that time?
Your Lordship will give Tuesday.
Tuesday. By Tuesday, opposition reply by. Then I'll take it up after vacation, or I can.
Yes, Lordship kindly takes it up after
easier.
vacation.
Yes.
Your Lordship,
Then I'll give you till Wednesday.
No, I think my learned affidavit file got changed.
No. Again, Mr. Sinha has succeeded.
Your Lordship, I'm appearing for referendum 1.
I'm appearing.
I'm filing on time.
Number 6.
The greatest relief is that I don't have to argue this before vacation.
To all concerned.
To all concerned.
Your Lordship, the matter may be taken up after the first week of reopening.
After 1 week after the evening, I mean, it will be on 12th of June, then I'll keep it.
Your Lordship,
I'll give you time till Wednesday to file your opposition, reply within returnable day.
Very well. Your Lordship, may be taken up on 13th, not on 12th.
Very well.
Lordship, my affidavit in opposition is ready.
File it today, take it on record. You are for the respondent number?
6.
Very well. The affidavit in opposition filed by respondent number 6 today be kept on record. Full stop. The time for filing affidavits in opposition by the other respondents is extended, on the prayer of counsel till May 17, 2023. Full stop. Reply, if any, shall be filed by June 9th, 2023. The matter shall be listed on June 13, 2023.
Great. Your Lordship, may I take your leave to mention that my name was wrongly mentioned. That has not been corrected in the previous occasion as has been directed by you.
What is the name and
Anjan Chakraborty, it should be Anjan Chakraborty. It can be recorded about that.
Anjan Chakraborty?
Yes, on the previous occasion. That has been, the direction was from his side.
What was it recorded as?
Pardon?
What was it? Anjan Chakraborty is the recording?
No, in the previous order, it has been wrongly.
What was recorded?
Anjan Chakraborty. Anyan Chakraborty. ANYAN.
Thank God. I thought it was a different spelling.
No, that can be corrected.
Onion is more towards Sanskrit. Your name is also recorded wrongly recorded.
Correctly recorded.
Very well.
Lordship, may I have a leave to file a short reply to the supplementary affidavit filed by the petitioner? It's been served on us on 1st of May. I've handed up my affidavit.
No, they have left after this. No, not now.
Right.
You can try your luck. You can come ready with that.
Very.
But I've not granted that time.
Very. Item number 10 and 11.
This is my application, Your Lordship. On behalf of Mr. Kaur, I'm praying for a short passover, Your Lordship. Mr. Anirban Kaur, Your Lordship. This is that rent control matter which Your Lordship heard.
Yes, he has to answer.
Then let
Yes.
My lord,
Yes, Mr.
Yes. My lord, I have taken specific instruction. If your lordship so desires, then the old method
If it so commences to your lordship,
No,
can
sir,
be
the
introduced.
difficulty is
Yes.
you have already filed an opposition.
Yes, my lord.
Not you, your client has filed.
Yes, yes.
Now you have seen the documents.
Yes, my lord. Yes.
Now you cannot be so casual in a contempt matter. That
No,
is a difficulty.
This
You
is the
means your client.
Yes, yes, my lord. I've received the instruction.
Even if you are a rent controller, even if you are a statutory authority, even then,
Absolutely,
we
absolutely.
cannot also be so callous in a contempt matter.
No, my lord, certainly not. My
That
lord,
is the difficulty.
and one lord, one thing.
Could it have been credibly accepted after
Yes,
5
my lord.
years?
Yes, it can be, my lord. Perhaps
Satisfy me on that.
Yes, my lord. Perhaps I could not make that submission on the last occasion.
Satisfy me on that. That
My
will
lord,
be
kindly
sufficient.
take page 30 for once of the
30, yes.
affidavit. Yes. Page 30, which was shown by my learned friend.
Right.
Page 30, as well as page 76 of the contempt application. Kindly, my lord. I'm led by Mr. Learned GP. I'm led by in this matter.
He has advised you that is sufficient.
Yes, yes.
Yes.
My lord, page
But
30.
he had been taken ill yesterday, so that's why I've been
Taken?
ill, my lord.
He.
Yes.
He got very, my lord, so that's
He'll
why-
never be ill again in court. I
that's
can
why-
assure you that.
May I just point
I can
out this?
assure you that.
May I just point out this, my lord? That's why I told him, he came to me. I said, he will do the matter, I'll be.
Yes,
That is
absolutely
what I
right.
told him.
No, it is true that I had to visit the medical unit on the last occasion. Yes.
No problem.
Never do that.
I
Take some time before doing that. And you may start neighing or barking or because that treatment is also sometimes meted out.
Always done, my lord. When the pilots made some mistake, the next thing they do is send them out.
It
for
may
a-
be a veterinarian treatment also. I mean, that's why be cautious on that.
Yes.
No.
Shouting yesterday and barking today will be very difficult for us.
But may I say this, my lord? In a lighter note, my lord, when he went and
This is all in a light note.
wherever he went, my lord,
Subject to whatever already is passed in the contempt.
wherever he went, my lord, I said, look, if the doctor found you ill, then you're not ill.
No,
Then I told him,
the machine said my BP got high. That much only.
BP got high.
Yes, yes.
We have to measure our BPs.
I know, I know.
Each
Well,
and every matter.
Yes,
that
yes,
is
yes.
also what I told him. my lord.
Yes, yes. I was.
Every matter, not only one matter.
Yes.
Yes, anyway, what
Yes,
is
my
it?
lord, kindly take page 30.
30, yes. 30 and 76 together.
76 together. My lord, the same copy. Last occasion, your lordship wanted to see whether it is sample copy or not. My lord, kindly see, this is the sample. Your lordship is seeing the same copy. Now, my lord, there was one issue raised that rainfall month, April 28, which is being submitted on 31st of January 2023, whether it can be done or not. Now, my lord, the system allows this. It is, I make fair submission before lordship, my lord, it is not in consonance with rule 20, section 21, because it has to be within 15 days. Admittedly, my lord.
Now tell me something. Does the system have any protection against that?
For that, my lord,
Then
there
that
is no-
software has to be
no,
modified.
for which the authority has already.
He can be.
Yes,
He
I've
could
already
have said that.
Yes, I've already stated in my affidavit that we have informed the
whatever you said.
department. We have informed the department that kindly give some extension of this 15 days. Otherwise, there may be case of default.
Mr. Rai,
Lahiri,
you're not
Lahiri.
Mr.
Lahiri.
Lahiri, Mr. Lahiri, sorry.
Yes, yes.
Forget your last name. Mr. Lahiri, it's not a contempt to make commit a mistake bona fide. But it's a contempt if you mislead this court. That is the difficulty. So you have to be candid before the court. The system does not contain this rider. So we'll rectify that. That's a different proposition altogether.
Yes, sir. May I just show one document for which we have already
So
said.
if that is not there, the rest will follow.
Yes, yes, we have already. Yes, yes. It is
Because
not.
if that safeguard is not there in the system,
It is not.
then this may happen. Otherwise, it cannot be. I mean,
We have already.
ex facie, I cannot say this is invalid.
Yes.
Invalid in law, but that is.
We have.
May I just say this for 1 minute? if you're
Yes,
permit?
yes, please.
My lord, first, obviously, my apologies, my lord, whatever has happened.
Yes,
my lord.
yes.
My lord, let us try and understand, my lord, in this, my lord, there is a public policy which is behind this entire thing. I'll point out why, my lord. My lord, your lordship knows manual presentations of anything, my lord, has that much of, my lord, transparency problems. Now, my lord, that is why intention was to make it online.
That's fine.
Now, my lord, my lord, your lordship knows very well, my lord, online system, as a matter of fact, we are also facing this with the CGST problems are also there, my lord. We are also facing it on a daily basis because NIS is the authority, which is the designated authority to make out all these things, my lord. Now, my lord, these problems are cropping up. As a matter of fact, yesterday when I found that this wouldn't be beyond rule 21, but maybe again section 21. Because the requirement
not beyond rule 9(4).
It is. So that is why, my lord, these are the nitty-gritties which we inform. Now that has to be done. But my lord, in this case, my lord, because you cannot take something beyond 15 days. I accept it, my lord. But my lord, these are the problems which appear in the
Very serious problem.
very similar. It has been already.
The law is being flouted then.
I know
in every matter.
My lord, your lordship, I had my lord, but my lord, may I just say this, my lord?
Then this cannot be implemented without this.
My lord,
You have said that it has been implemented. It is going on.
my lord, this document.
Just understand the implication of that, Mr.
And
Rai.
I understand, my lord, but this document which has been shown to your lordship, my lord, this does not show, my lord, that my lord, we have
I'll
immediate.
direct Mr. Jibon Varman to be present in court.
Yes.
That will be the best thing.
My lord,
Manufacture Mr. Jibon Varman in the meantime.
my lord, then may I say something, my lord, if your lordship permits me, my lord, with humility again, my lord. My lord, Jibon Varman is an example. Jibon Varman is an example to show your lordship what is the process followed. Because your lordship will kindly appreciate the order which was passed by your lordship. As a matter of fact, with humility again, I submit, my lord. Your lordship found my learned friends to have done a good job. And therefore, your lordship says, I'm not passing any direction. And your lordship had granted my learned friends to approach any forum if there is any problem. Your lordship then, my lord, with humility again, I say, must have acknowledged that this is a policy which is being brought in by the government. And yes, it is falling in place, or it is
No doubt on that.
attempted to fall in. Now, the question is, these things were being shown because the case which has been now sought to be made out, my lord, by my learned friends, the contempt application, is at variance with what the writ petition was. Whatever they're making out the case before your lordship. But we went out of a way to try and show that this is how it is being done, because they are saying that they have not received the challan.
Right, there's a huge difference, gulf of difference between an individual bona fide attempting to implement the law and the state flouting the law like anything.
Malad,
this software, nobody checked.
Malad, I'm coming to that, Malad.
Maybe the rent controller is not responsible for this, but whoever made the software,
Malad, definitely,
there is nobody to check.
Malad, definitely.
Section 21, Rule 9(4) is the state legislature's
Malad, that is why, Malad, steps are, we have already informed. Malad, yesterday I got to know because there was some, I'll point out, Malad.
Already so much damage has been done then.
Malad, I have already said that at least we need to find out how much has been, who and how many has been implemented in
Why
this.
did you just annex a sample copy when there are live examples? Because you have said that
Well, they are live also. They are also live here.
You have annexed those also.
Malad, may I just point out how this happens, Malad? Because I took a tutorial yesterday because I was also not, because I was not getting it, Malad, how this is working. Malad, it appears that there are two processes. One where there is no one who has filed.
Yes, one is
rents.
physical one. Yes.
No, Malad. Not
oh, among the online also.
Among the online, Malad. One is where there is no earlier online submissions and who is coming for the first time. Rather, coming for the first time and a continuance of online. If it's a continuance of online, the person has to first come to one help desk where they have to show the last month's rent.
For the online upgradation, they have come physically, like BSNL sort of.
Two steps, Malad. There are two steps. I'll point out. You can do it pure online, or you can come there. They will give it to you. And once they give it to you, that is fed into the system.
No, a pure online system is also available.
Yes.
That's there.
Yes.
So by that, this can be done. This can happen.
Well, this document, may I just point out, this document does not go out to the public. What is there before your lordship? The one which your lordship is seeing. That's why I was just trying to explain.
I want to see what goes to the public.
Malad, what goes to the public is, Malad, kindly takes.
You could find out one of the copies after so many pages.
Well, because these are examples which have been given, and it's a step-by-step process which has been given.
Have you stated these are examples, Mr. Rai? In your
that is.
Let us see once.
No, Malad. They are saying this.
Is your merrily shifting stance?
No, I'm not one.
Let us. You are saying these are samples. Let us see your affidavit.
They are saying, Malad, kindly sees.
No, where is the reference to this annexation?
Yes, Malad, I'm taking a lordship, Malad. Yes. Kindly comes to, this starts at paragraph 3.
Give me the page number, please.
Page 3, Malad.
Page 3, right.
Page 3, Malad. They are dealing with, Malad, modalities. It is nothing to do with my
copies of the relevant challans.
Yes, because I was trying to show
sample challans or pro forma challans or something like that. Malad, photocopies of the relevant challans are annexed.
Malad, relevant challans is in relation to with humility. Malad kindly appreciates. In 4, Malad, we have been trying to deal that whether joint tenants can be included or not. So that is the relevant challan. That is what they are trying to say, Malad. Sample challan, these are challans. These will be the challans. But it has been taken out to show that the system can incorporate. That is one of their objections. That the system cannot.
At the very, which page you are relying on?
Yes, madam. It page number it is page 35. 35, madam.
35, yes.
35 kindly sees. But if your lordship kindly gives me 1 minute so that I can give the way it is done.
1 minute I'll give you, definitely.
1 minute. My lord, now as I said, the person comes. When the person comes, my lord, it is fed into the system.
Yes.
From there, it goes to GRIPS. That is the controlling body, my lord. Now, GRIPS sends back, my lord, a GRN number, which is that which your lordship is seeing, which does not. And I think the affidavit could have been happily worded, much more happily worded. But it says not paid, if your lordship sees that. There's a mark, my lord. Watermark, my lord, not paid, which you just, your lordship just said, oh, my lord, may I take your lordship to page 20, 30, 30, my lord. My lord, seen that?
Not paid, I've seen.
Yes. So, my lord, this is something which comes back to my system, as in the rent controller system. It is not open to the public. What happens, my lord, on this, my lord, is again fed into the system, and then the challan comes out, which is, my lord, since your lordship is so minded of the Jivan, no, I'm pointing out, because the GRN now
explanation regarding you are verbally giving these explanations in a contempt application, Mr. Rai.
My lord, that
this is very unfortunate.
My lord, may I just point out, my lord, kindly appreciates, my lord.
You say you have a system, one copy goes to one, whatever goes to you, not paid. That's the explanation, only explanation, because not paid means that it does not go to the public.
It does
maybe one of the explanations. But these explanations, there is no transparency in your affidavit.
My lord, may I be permitted to explain this, if your lordship permits me, my lord? Because I think it is necessary, because the system is something which has
no,
not...
Mr. Rai, then I'll give you supplementary affidavit leave, file it on Tuesday, but that has to be very comprehensive on this.
I want to.
Not unnecessarily technical to dupe the court.
My lord, kindly does not say this, my lord. I am not here to do that, my lord.
You are not here to do that. But this affidavit of your client is very clear.
My lord, I don't think there would be any reason to dupe, your lordship, my lord.
Reason to dupe?
To dupe, my lord.
I don't know.
Because, my lord,
in a contempt application, this is as open as possible, Mr. Rai.
My lord, because, my lord, your lordship...
You have stated in your opposition, relevant challans have been annexed. What do you mean by relevant challenge? Sample challenge?
My lord, to show that multiple, because your lordship kindly appreciates what is the case being made out by my learned friend. It's a new case, but I'm answering to that.
No, it's a new case. They are saying that there was a direction on you to comply. The direction was that you have to accept from then on, and the previous ones also, by way of whatever mode.
That I will come to later, my lord.
No, Mr. Rai, what you have stated here is basically that the impression given at least here is that you have been doing that in compliance with the order, in regular course of business.
Regular course of business.
So if that is so, why produce sample challenge for this?
Well, sample means, my lord, an example.
No, your example
is not. It is my learned friend's case that they are not being given.
I deposit the money, Mr. Rai. I'm very specific on this. I deposit the money. I have to get a challan which has to contain the name of the, has the provision of joint owners, landlords.
Well, I can show that it is there also.
This is not that. Why have you annexed this at all?
There are others, my lord. I can show from that. Yes, this has been annexed, my lord. This has not been.
This is the first annexure.
Yes, my lord. This has not been explained. That is what I'm submitting, my lord. But there are documents to show that that has been done, my lord.
Which document shows it?
My lord, yes, my lord. My lord, kindly takes. My lord, that is why I've been continuously saying before your lordship.
Which one? Which
one? My lord, kindly takes, my lord. এটাতে জয়েন্টটা তো নেই, যেটা বলছে কথাটা বোঝো। I'm sorry, joint one, my lord, is something what I want to produce. That is what I said, my lord.
You said there are documents here also annexed.
My lord, that document is it is there, but it does not show the joint one, my lord. Page 35, kindly see. That is the. These are examples to show, my lord.
I did not challenge you, Mr. Rai. You are merely submitting in a court of. You are the GP, Mr. Rai. You are the government pleader.
My lord, what I'm.
You have a responsibility.
My lord, yes, my lord. I'm submitting, my lord. Kindly appreciates. I have.
You boldly submitted that yes, there are such challenges which are compliant with the order, and those have been annexed also.
These are the.
And you are failing to produce that. There is no scope of righteous self-indignation for you, Mr. Rai.
No, no, my lord, I'm sorry, my lord.
No scope of that.
My lord,
It's a palpably bad affidavit. Not only that, the annexures are specifically to mislead the court. Why not? This sample copy has been annexed. It has been stated on oath that no, this is a relevant challan. Copies of relevant challans. What do you mean by relevant challans?
my lord,
You're educated people. Your client is an educated person.
definitely,
The advocates are educated.
my lord.
You write there that relevant challans have been annexed. Those are sample copies which do not go to the public. What do you mean? I want to see whatever is public. Your private documents, let those be with you.
My lord.
And not a single challan complies with the order which was passed by this court. Here, annexed here, not a single challan. Show me one challan.
But the challan which is in compliance, that is not of multiple, my lord.
Then it does not comply. Then you are in contempt. A rule of contempt should be issued right now. Why not? Why not? Mr. Rai, why not? Tell me.
My lord,
As
that-
an officer of the court, as a GP, tell me.
my lord, that-
You are an officer of the state also.
Yes, my lord, that I will submit if your lordship issues a rule, my lord. Let me try and get this sorted, my lord. That is what I'm trying
How
to.
soon can you come back with a sorted copy?
মঙ্গলবার সই কোটা কোথায়?
Have you seen with your own eyes, Mr. Rai? Have you seen with your own eyes any of such challans?
My lord, the challans which
You have seen.
my lord, my lord, whatever I have seen is what I got from the briefs, and I told yesterday only I got the brief. That's why I come before your
Whatever,
lordship, my
whatever.
lord. My lord, what I'm trying to submit before your lordship is, my
What
lord,
you are trying to submit, I very well understood, Mr. Rai.
my lord,
But what you are trying to submit is not borne out by your records.
my lord, that I've if I can just put in a supplementary affidavit, my lord. Because my lord, I'll
Till Tuesday, I'll give you. At the most.
my lord, may I have one more day?
Depending on Mr. Kaur. One more day will depend on Mr. Kaur now entirely.
But I'll leave it on him. my lord. At least he has my namesake. I hope.
But his surname is different. He has to do it.
And may
Anyway.
not be to me, my lord. I mean, I'm also
You
also a school senior, so it doesn't matter. I think I'll take that advantage.
It is palpable from the affidavit in opposition filed by the alleged contemner, comma, despite the explanation sought to be given by the government pleader, learned government pleader, comma, that the same does not satisfy the query of court as to whether the order passed by this court in the writ petition was complied with duly. Full stop. Moreover, comma, the system sought to be portrayed before court is not transpiring from the pleadings of the affidavit in opposition. Full stop. It might further be noted that although certain annexures have been referred to in the opposition as within double inverted copies of relevant challans, double inverted clause, comma, those are now sought to be made out to be sample copies. Full stop. Some of the challans which are not sample copies according to the alleged contemner are also not compliant with the direction of this court. Full stop. However, comma, on the prayer of learned government pleader, comma, since the state wishes to clarify the system which is being followed before the rent controller, comma, a last opportunity to the alleged contemner to file a further supplementary affidavit explaining his position is being given. Full stop. Accordingly, such affidavit in opposition, such supplementary affidavit shall be filed on May 17, 2023. Full stop. It will be open to the petitioner to ask for further liberty to take out a rejoinder against the same on the next returnable date. Full stop. The matter shall next be listed on May 17, 2023 itself.
Lordship, just one indulgence, let my learned friend at least indicate what they disclose as a sample copy, because what they disclose as a sample copy has clearly been acted upon. So kindly let my learned friend disclose what they treat as a sample copy.
No, in the supplementary affidavit, that will be the last chance. In that, they have to explain this also. Because I have recorded those, the first few lines for that only. You have to give your explanations, Mr. Not so nonchalantly, not so casually, no. Not in a contempt matter. Whoever is appearing, Mr. Rai.
That is, no,
Your fairness, your learned friend's fairness does not mean anything.
Absolutely not.
Because I have to be neutral on this. If this is a contempt, your client has to be behind the bars.
I have not sought for that, my lord. But my lord kindly does not also shut me up. But I know if your lordship
Have I?
No, my lord, on the point
You
of
could not
whether-
have spoken so much, Mr. Rai, after
Absolutely
this
not.
affidavit
My lord,
in several courts.
I'm
And
saying,
that is the right
I'm
approach.
saying, my lord, your
Too
lordship,
much lenience has led to this now.
your lordship's
in
granting
contempt
me
matter.
this affidavit chance.
Not that, Mr. Rai,
But
but
my lord,
too much lenience is one of the factors which has led to this scenario. I'm telling you,
my lord,
all lenience, my lenience also.
understand.
I'm a part of that.
I understand, my lord.
But this will be your last chance.
My lord, definitely, my
Thank
lord. But I'm so grateful to your lordship on
Thank
that,
you for
but
that.
my lord, I'll take it later, my lord. I'm very grateful. And my lord, kindly, my lord, I'll try and explain what I wanted to say before your lordship, which also took my lord.
I hope you succeed in a trial.
I hope, my lord. I'm very grateful. তোদের খেলাটা তো বোঝাতে হবে।
12-13 years. আপনি একটু মাইকে বলুন, তাহলে শোনা যাচ্ছে না, ওরা শুনতে পাবেন, আমি পাচ্ছি শুধু শুনতে। আপনি একটু মাইকে বলুন। 12-13.
Item number 12 and 13.
My lord, we are appearing.
Your lordship, we are appearing for the petitioner.
Yes.
Your lordship is seeking for a short pass over.
Why?
My
Move
senior,
the matter.
your lordship, my senior is. dealing
You are
with
also in the matter.
No, your lordship, I'm not. I'm not the advocate on record, your lordship. Short pass over, your lordship.
May I make one
Yes,
submission?
yes.
I am not opposing this prayer. Rather, I am supporting his prayer, but in a longer time, because the last occasion I also
Need not support his prayer. The reason is behind you. Yes.
Now, a second.
It has to be your own prayer now. He'll move the matter. He's ready.
Yes. Now, my lord, my client has preferred an appeal, but the appeal.
Sir, please use the microphone. I can't hear you.
Lordship,
I can't hear you.
Oh. My client
Still can't hear you.
Yes. Now,
Your client
has preferred an appeal, but Miller.
Why are you so apologetic for that?
No,
rightly so.
Just now,
the right.
Just now, the matter I am afraid from yesterday.
Because of the last matter.
Yes, from yesterday.
Yes, same fate will come to your client also, Mr. Paja, if you do the same thing.
That's why I'm saying.
I have to be fair to all sitting here.
Yes, but here I am not.
Mr. Paja is appearing, Mr. Rai is appearing.
I'm not
You are
saying
fair, otherwise that cannot be a factor.
No.
That cannot be a factor. If your client violates, I'll take action.
Yes.
As a court of law.
Now, Miller, my appeal is there, but still hasn't come to the list. Now, another appeal I am told.
When did you file the appeal?
After delay. February 3rd February 23. 3rd February to.
So we are in May now. So you should be afraid then. You should be afraid then.
Now, Miller,
because we are in May. Today we are on 12th of May. 3rd February. That was 3 months back.
Yes, 3 months back. Now, Miller, another appeal is there.
No, you're deliberately sitting tight over the matter, Mr.
Probably, Miller, I am.
3rd February you filed that appeal. Why didn't you mention it before the appropriate bench? Bench was functioning all along.
No. My junior has mentioned the matter. Not that we not mention. Miller, 1 minute may I get for you? Miller, another appeal on same point is in the list. So, Miller, I thought that I am requesting that.
What is the point involved?
The point involved, that is negligence for.
That is an arguable point, negligence. This is regarding compensation.
Yes.
Minor boy died.
So when will that appeal be taken up, Mr. Paja? Before vacation? Obviously before vacation. This is a content matter.
Yes. I will try my.
I have not yet heard your learned friend, in fact. So I'll hear him after you.
Yes. Now, Miller, we are trying, but the appeal court has, honorable appeal court has pleased to observe that both the appeal will be tagged together. That I can say.
No, that has not been direct problem. Mr. Rai is correcting.
Yes, I am.
Just mention.
I'll allow my junior to say, please.
Matter was mentioned before because the
He was aware.
similar point your lordship is directed to pay compensation on the basis of the calculation.
When is the other matter fixed, Mr. Rai?
It is in the list, item number 820 of the combined list.
820?
In the combined list. At that relevant point of time, learned Chief Justice, as he then was, was told that it will be after, if the point is same, let me decide first that matter, then your matter will automatically,
Yes, yes, right.
that is the position.
What is the current item going on there?
Today,
No, not today. I mean, how many matters are there in today's list?
no, that is combined list
820 will never be taken up.
820.
I could not have taken up even if I was the division bench.
820
In this lifetime or this determination, probably I could not take up.
the bench
820 cannot be taken up. You have to mention it, Mr. Rai.
under the heading of hearing.
I'll give you the handle to mention it in my order. Yes, what do you say?
My lord, two aspects. First of all, they are vigilant to appear without notice in the contempt, but the appeal was preferred out of time with section 5. There was a delay because the order was of 11th November. There is a section 5 application which they have filed. We have the information on hand, which shows there is section 5 of Can 1 which is pending. That apart, my lord,
I don't
there
know
were-
what should I say because that matter has been tagged with the other matter.
it has not been tagged because we have been served with the copy of the section 5.
Section 5 আছে আপনার কাছে?
Copy, yes, we have been served with.
Huh?
Yes, we have been served.
We have not, I am
You
told.
have not been served.
Status.
It is
We have not
It's
filed.
your
that
section
note.
5.
The High Court
There is no
information
section 5.
status shows there is a Can 1 section 5 file. It has been served upon us.
And one may not be section 5.
It is stay application.
It is stay application.
Stay application. May not
But
be
it shows
section 5.
section 5, maybe in the wrongly in the list.
Anyway, but I mean, if it's item 820, Mr. Pajay, it will never be taken up.
That apart, my lord, there were two orders. One was for a payment of cost for delayed filing of affidavit in opposition in the, my lord, case. That order also they have not complied
In this case,
in the writ petition. In the
during pendency of the writ petition.
During pendency of the writ petition, they had come up with a delayed affidavit in opposition.
Yes.
That
What
was
was the
allowed-
cost amount
10,000
for that affidavit?
for affidavit.
Not
For a-
paid.
Not paid till date.
করেছে?
And the matter was hard upon the undertaking that they will be paying it. And that order is not under challenge. The final order is under challenge in appeal. And kindly see page 33 of the contempt application. That is the order awaiting costs. It starts,
এখনো
No.
দেয়নি? আমাকে
They have not.
দিয়েছে।
kindly see page 32 onwards is the order.
32.
To 32.
Contempt application.
এটা কি?
Earlier, the order was for payment of 1 lakh cost. They had taken out review that was reduced to 10,000 by your lords.
Who directed one like?
Justice
Banerjee.
Banerjee, as the notes.
Well, that was reduced by me.
Yes.
Even that was not paid.
It was not paid.
1 lakh to 10,000.
No, that is mentioned in, yes, page 32 is the order.
Instruction নিয়েছি, আমার কাছে instruction payment করে দিই।
Oh, that was not paid.
That has not been paid.
Contempt to is order against.
Final order.
No further time, Mr. Pajay. No further time.
In fact,
I'll record your submission that appeal is pending as item 820 in the combined list. I'll record that. I'll give my reasons. No.
Instruction দিতে হবে।
Why didn't you comply? You had to comply.
yes, yes. Now, Milord, my junior is saying, Milord, let him.
You have
Milord,
not
take-
even
take-
assessed the compensation.
Yes,
You
yes.
preferred the appeal on 3rd of February, Mr. Paja. The direction was on you to
Certainly.
do it within 1 week probably.
Yes, Milord.
Within 31st of December.
Within 31st of December.
December.
No, no.
Certainly. Milord, my
Post
junior-
facto filing of an appeal cannot cure your case.
Milord, one
I'll
thing-
issue a rule of contempt, Mr.
Milord, my junior
If
is
you kindly
saying
present.
that he has no instructions whether it's paid or not. Milord, may I get only?
Should have come with this. That is the first instruction you should have
Of
taken.
course,
Mr. Paja.
of course.
There was a direction for cost.
Yes, yes, yes. Of course.
I'll keep it on Monday at the top
ঠিক আছে. It's all right.
before the motions.
All right. So I will request my junior to take.
Learned
instruction
counsel
whether
for the
negligence.
learned counsel for the alleged contender submits that an appeal has been preferred on February 3, 2023 against the parent order in connection with which the contempt application has been filed. Full stop. The said appeal, comma, it is submitted, comma, is appearing as item number 820.
820.
820.
820 in the combined monthly list of the division bench. Full stop. Next para. It is submitted by learned counsel for the petitioner that the same may be time barred, comma, which is disputed by the alleged contender. Full stop. Be that as it may, comma, it is apparent from the submissions made by the parties that although the direction in the parent order was to be complied with
Assessment within
by December 31, 2022, to the effect that the WBSEDCL was to ascertain the amount of compensation payable to the petitioner on the demise of his 11-year-old son Rajesh in accordance with the said direction, comma, the appeal was preferred much after such deadline. Full stop, next para, such post facto filing of an appeal, comma, not only after waiting throughout the period during which compliance was to be done, but more than a month after that, comma, does not justify the prayer for adjournment in the present contempt application. Full stop. Next para. However, comma, it is it is further submitted by learned counsel for the petitioner that not only the alleged contemner has contravened the parent order dated November 22, 2022, passed in WPA 5087 of 2018, comma, a previous order passed by this court, comma, reducing a still previous direction to the alleged contemner to pay costs of rupees 1 lakh was reduced to rupees 10,000 payable within a week thereafter, comma, was also not complied with. Full stop. Next para. It is prima facie evident that the alleged contemner is in the habit of non-compliance of the order of the courts. Full stop. However, comma, since learned counsel for the alleged contemner does not have any specific instructions regarding whether the previous costs were paid or not, comma, the matter is adjourned on the prayer of learned counsel for the alleged contemner till Monday, Tuesday, till May 16, 2023, when the matter shall be listed at the top of the list for passing further orders.
Only one thing may I point out. Their appeal against this order under
My appeal
is not in the list.
Not in the list.
824 is the other matter.
Other matter, where the honorable court directed to tag with the matter.
Should একটু বলে দাও. Is submitted by learned counsel for the alleged contemner that না এই as appear which is item appearing as এটা ওখান থেকে বাদ দিয়ে তার আগে একটা জায়গায় বলেছি যে
এরা সোমবারে গিয়ে মেনশন করে appeal
তারপর
এই order দিয়েছে। You are in great trouble. বল।
the said appeal কথাটা চেঞ্জ করে it will be another appeal preferred on a similar issue as the same is appearing as item number 820. Thank you. Thank you.
Item number 14.
My lord, I am appearing for the writ petitioner, my lord.
Yes, please.
And there are two applications filed and by the intervener, my lord. One is addition of party and another is recalling of the order dated 26th February 2021.
Yes.
But those applications were not served upon me, my lord. Actually, that is not in my hand.
So, the present application has been served on you.
No. A copy may be given to me, my lord. I have not
I
received.
have got an affidavit of service.
Yes, might be.
You are appearing for the state government.
But I am the worst sufferer because of.
My lord, the thing is that, sir, the thing is that the order dated 26th February 2021 has already reached its finality. The writ petitioner has filed the contempt and the rule was issued, and on the basis of the rule, the particular applicant has been faced certain consequences.
Be that as it may, yes, what I'll come to Mr. Mojumdar last.
1921, sorry, 2021.
Can you please take the microphone? Yes. 2021.
21, the work order issued to a supplier in a Purulia mental hospital died.
Oh, that died.
Then, what happened?
Diet is the latest racket, sir.
Then, what they arranged, because our duty is to supply food, including drinking water, to the patients, indoor patients.
Would not
24
stop for a day also.
for a moment, Malad.
Yes.
Then, Malad, what happened? Then we asked the son of the gentleman to continue. But in the meantime, he also expressed his inability. Then, Malad, we have issued, requested the next lowest tenderer to supply the food. In the meantime, we have issued a tender process. That was challenged before your lordships. And your lordships granted an interim order. Now, that was not within our knowledge when work order was issued. Contempt rule was issued via your lordships. And pursuant to my lord's order, we have issued the work order issued to Mr. Mujumdar's clients. And that is, he wants to be implemented as a party respondent in these petitions and application for vacating the interim order. This is the order passed by your lordship on 19th of April. Last sentence of the order, passed kind of of the order.
No, this is an application for
Additional party whose tender work order has been cancelled.
petition. 89. So, one is for additional party, that is can 6, and can 7 is for vacating.
Additional party can 7 is the recalling.
Recalling is by
Recalling is also made by the same person.
same person. Let me hear Mr. Mujumdar then first on the additional party
If
application.
I have committed a mistake, Mr. Mujumdar will kindly correct me. No, what I've said.
Yes, Mr. Mujumdar, what is your ground?
The writ petition was at the behest of a bidder who was found to be not qualified by the state authorities. The writ petition, the hearing of the writ petition at the prima facie stage was going on when the state was unable to produce records, or in the midst of the hearing could not be concluded when an interim order was passed. Now, in the meantime, after passing of the interim order, it appears that we had been awarded with the work order as a successful bidder. From that proceeding, from that order, contempt proceedings were initiated, and the state submitted before your lordship that we shall be cancelling the work order issued to the writ petitioner. I am not my client, the applicant. I had put in 7,60,000 rupees as security deposit, had deployed workforce. I have spent a lot on the purpose of execution of the tender. It's for a period of 3 years. Now, if I may be able to persuade your lordship on the point that the writ petitioner had no locus standi, he is obviously somebody who has been set up by the erstwhile bidder.
Mr. Mujumdar, you have taken advantage of a wrong done by them.
I
may not be intentional. I'm not saying deliberately, but you have taken advantage of that. And taking advantage of that, you cannot be post facto added as a party to the writ petition. How can you?
He was not. If I can just not, I may be a proper party, may not be a necessary party.
Not even a proper party. Why I say, Mr. Mujumdar, this has nothing to do with the adjudication of the writ petition at all. You have nothing to do with that.
He has challenged the tender process in respect whereof I have emerged as a successful bidder.
Oh, in the writ petition itself.
The process in which in respect whereof I am a beneficiary.
So you became a beneficiary later on.
Later on, of course. After the interim order. I became successful earlier.
That was in violation of the court's order.
No, I was successful earlier. The work order was issued subsequently.
This addition of party cannot be allowed.
I have become not when your lordships
don't have a right to get implemented in the writ petition.
Not when your lordships are deciding a matter. Not your lordships are considering this with regard to the factual aspect or not the situation prevailing as on the date of final adjudication. Now, today, if your lordships are persuaded,
not an illegal beneficiary.
No, I'm not. If I may be persuaded, if I may be able to persuade your lordship to hold that the writ petitioner on the date of passing of the interim order.
I will not listen to you on that. You have no locus standi on.
No, as on the date, even if I have not accrued a valuable right.
At that point, even if you are entitled to canvass that point, that entitlement was subject to the result of the writ petition.
But I just give you lordship an example.
You came in after the writ petition, that order was passed.
No, I just give you lordship an example.
Mr. Mujumdar, only one thing, the order was, the writ petition was disposed of. Fine.
No.
It was
Still pending.
I'm not, suppose not at that stage, I was only a member of the selection list.
Yes.
I was at the most a selected person, but not appointed as a contractor.
No, below the bid was opened.
Let him complete.
Let him complete.
Mr. Sinara, please take your seat. Only you take your seat, the others will remain. Yes, Mr. Mujumdar.
Not I might not have a crystallized right in my favor on the date of passing of the interim order or on the date of moving of the writ petition. But qua a successful, not a successful bidder. Yes, a successful bidder, but who has not been awarded a contract.
Successful in something else.
Not I might not have got an accrued right in my favor so far as an awardee of a contract is concerned. But of course, as a selectee, not I had some right to ventilate. And to show to your lordship that the writ petitioner did not have a right at all to maintain this writ petition, being a bidder who was participating in a tender process in a hospital 100 kilometers away.
Was there any bar in the tender, NIT?
There was no express bar. Not he said that, no, there was not. He said that for other tenders, there is no such similar clause. Number one. Number two, he's unqualified for other conditions as well.
Even if you are a selectee, I mean, what was your stage? Actually, you have pleaded that.
I had not been awarded the contract at that point of time.
Then Mr. Majumdar, do not come in.
Later on.
There may several persons might have been collaterally affected. All of them cannot be implicated.
No,
in the
no,
writ petition.
whoever might have been selected as qualified bidders.
How many were there?
Please
There might have been umpteen.
Please see page 88. I'm sorry, page 83.
88 of your application. Not your application.
Context Can 7.
Page 88 of that.
Yes, page 83.
Page 83. 9 persons submitted the tender document.
Yes.
Page
You are one of these.
The first name is Bongshidhar Maji. He's qualified. Now kindly take note, United Supplier. Serial number 12 on the next page. Not qualified.
November 2021.
No, he had challenged the clause of the NIT.
Yes.
NIT.
Not at the behest of a
That is arguable. What you have now argued, because if you were among those candidates at that point of time, you had succeeded at one stage. No, you were just a participant there.
And found to be qualified.
Found to be qualified means
To be awarded a contract.
There are 2 stages, just give it. First,
one is technical.
technical bid and financial bid.
This was technical.
Technical bid.
They succeeded in the
technical bid.
at the point of time when the writ petition was filed or when it was heard.
Writ petition was filed, interim order was passed, and in violation of the interim order, bids were opened. That is, Milord.
Technical bids were opened in violation.
Yes. Both bids were open, and he is
No.
claiming his right on the violation of the particular things.
Mr. Majumdar, very difficult.
No, I am submitting before your lordship, not whatever may be the outcome of the writ petition. Today, if I may be added as a party for the purpose of trying to persuade your lordship to the extent that, look, the writ petitioner who has tried to stall the tender process is nothing but a spanner in the wheel for the purpose of not sponsoring the cause of some other persons, rivals in business. It's not a bona fide writ petition at all. He has his place of business 100 kilometers away.
No,
Number one. Number two.
Said, Majumdar, why I cannot open that issue at your instance. I cannot open that issue at your instance.
It's only at the stage of interim order, not when the
Even
things, not today, please see the
you are in
situation.
violation of an order. They are in violation of an order. In violation of the order, you have been your bid has been opened. Now that cannot be given a premium to Mr. Manju.
No, I don't say, I don't claim a
It
premium.
will be if it entertain your application at all.
Today, when your lordships will be considering the aspect of granting a relief. Today, when the
State represents your interest, not the state, the respondents, whoever it is, they represent your interest sufficiently. You are claiming through them because they have opened your tender bid, they are issuing the tender.
But
So you are claiming through their rights. If they have faulted, then you are sufferer. You are a sufferer, necessary sufferer.
now, today the question is,
Yes,
I don't claim an equity by reason of not a beneficiary of an
you cannot.
act which is passed
Obviously,
in violation of an order.
no.
But today, when your lordships will be when your lordship will be considering the issue on in finality,
Even then, they represent your interest sufficiently. Insofar as this, the subject matter of this writ petition is concerned.
now, of course, but at the same time, I have factually spent or not suffered consequences.
You have suffered in your own choice.
Maybe no, not own choice. It's unconscious
We
insofar
don't
as
know
I'm
that. We
concerned.
don't know that.
But I was not a party to the writ petition when it was.
You are not.
It was his duty to include me as a party.
True.
Even as a selectee.
Even then.
Selection was made after the passing of the interim order.
All selectees, if all selectees are included in all the matters, it cannot be.
It should
In a
be.
tender
But
matter,
there is. But I
if
can.
the clause is disputed, if a clause, the veracity or validity of a clause is disputed, why should all the selectees be? I mean, everyone's rights go. Even as selectees, their rights are dependent on that clause.
That is subject to the outcome of the final adjudication.
True.
Number
Because their rights are dependent on that clause. If the clause is held to be valid, then only you have a right. We cannot proceed on that premise.
Today,
If the clause is set aside, then you don't have a
I
right.
don't need to cite authorities before your lordship to satisfy your lordship's kind conscience.
Yes.
That a bidder who participates in a tender process participates with full consciousness, with eyes wide open, and he cannot challenge a particular term of a contract after having of a bid of a tender after having
Open that
participated.
argument, Mr. Mujumdar.
But he has
Need not cite judgments because I won't let you. Because you don't have the locus standi to do that.
Correct. Now, not if I can persuade your lordship, not I.
Even if it was a palpable illegality, that order was prima facie illegal, unless it was a nullity otherwise, without jurisdiction or nullity, inherent lack of. Otherwise, Mr. Mujumdar, no.
Today, the writ
Nobody
petitioner
can reopen.
ought to have brought it before your lordship's kind consideration that he is a participant in the bid process. Had this fact been brought to the notice of the honorable court,
And your instance, we cannot look into that. You may supply your written notes to them, to the respondents who are already there in the writ petition.
No, I'm
Mr. Mujumdar, I cannot permit. Or you may be engaged by them also. So,
far from the stage of further stage of imagination.
Don't do that. You won't do that.
No, I try to persuade your lordship on this score. But the writ petitioner ought to have brought it to the court's notice that he had participated in the writ process. In that event, your lordships might not have been persuaded at all to pass the interim order. A clear suppression of fact.
Cannot hear you on merits.
Not I showed your lordship the effect of the order. Please see 101. I had been asked to leave the premises lock, stock, and barrel with my employees' utensils, whatever I had spent on the project. Or
You're lucky that no investigative agency is there for that. You're lucky. So,
but is it a specially constituted investigative agency? That
yes, we can. You're lucky.
No, it will relate back to the date of initiation, then, at whose instance the writ petition was.
Yes, true. That's true.
But please see page 101. It's a non-qualified bidder.
No, you have succeeded as a result of a violation of court's order, Mr. I have to abide by that.
Not very well. But I am
whoever passed the order. I mean that's not important. You know that.
not even
then.
Not I may be a necessary party in the writ petition, if not for the purpose of vacation or modification for the time being.
No, I'm not thinking about vacating at all. I'm thinking about the main subject matter of the
Correct.
writ.
No, I'm not. There is a tender clause under challenge. Not kindly visualize two situations.
Beneficiary.
Not one. Not kindly
At
visualize.
least irregular beneficiary.
Very well. Kindly visualize two situations. Not one is a writ petition placed before your lordship's kind consideration when there is no interim order passed and there is a clause of tender under challenge. But this is one aspect of the matter, and the tender process has substantially progressed to the stage of granting of an award of a contract.
This question cannot be gone into, Mr. Mujumdar, because there was an order here. It would be a different situation. Yes, you are right.
Now, I'm not.
At that juncture, if you had come before the order was passed, definitely I could have considered this. But after the order is passed, a tender has been opened in violation of a court's order. No.
Yeah, please.
You're asking for your rights on the after that. So that cannot.
But only thing that I can only seek for variation, modification, application for addition of party if I am made known of a fact.
No, Mr. Mujumdar, the only right you have, Mr. Mujumdar, is preferring an appeal against that interim order with a leave before the appellate court, which you have. That is the only liberty you have in the circumstances.
No,
you are an affected party. You can you know that, Mr. Mujumdar.
No, I
You can
just
very well file an appeal with a leave application. I am a necessary. I have the right to prefer an appeal because I am an affected party. You do that. I'll give you that liberty here while rejecting this.
now one example I have given to your lordship. The other example is one on hand. The situation on hand, that wherein there has been an interim order, not hearing concluded on merit.
No, no, definitely not.
But an interim order was passed because the hearing could not be concluded. Now, not by reason of this interim order not having been communicated, or whatever may be the reason, not I had been awarded with a tender, a contract. Now, not I come to know of this
Contempt
contract.
is pending, Mr. Mujumdar. You have taken benefit of that, and you are claiming to be implemented in the writ petition itself.
Not I can only seek impediment when I come to know of my right being affected.
True, but there are other relations.
Number one. Number two, even as a selected bidder, I ought to have been impeded.
I'll deal with that. The addition of party application bearing can 6 of 2023 is taken up for hearing. First up, the petitioner claims to be a successful bidder in the tender process, which has been challenged in the writ petition, that is WPA 3965 of 2021. First up, it is an admitted position that such success was the result of opening of the technical bid in the tender process by the respondents in the writ petition, comma, which was prima facie in violation of a court's order. First up, an interim order of restraint had been passed by this court in the writ petition, whereby it was illegal, it was unlawful for the respondents in the writ petition to open even the tender process or proceed with the tender any further. First up, despite such specific restraint order, comma, the technical bids were opened and the present applicant was allegedly selected as a successful bidder. First up, next para, learned counsel appearing for the applicant contends that since the repercussion of not impleading the applicant in the writ petition would be fatal, comma, since the writ petition, since the applicant would have to vacate the premises in extremely short notice and stop the work already started, comma, for which the applicant has invested amounts, comma, such contention cannot be accepted. First up, it is well settled that the illegal beneficiary of the violation of an order of court cannot be given a premium to reap the benefit of such violation. First up, in the present case, comma, it is palpable that the success of the applicant was a result of flouting the order of this court. First up, even though such order was of an interim nature, comma, the same was equally binding as a final order insofar as compliance by the parties are concerned. Full stop, next para. The other limb of submission of learned counsel for the applicant is that even as a participant in the tender process and having been selected at the inception, comma, the applicant ought to have been implemented as a proper, comma, if not a necessary, comma, party to the writ petition itself. First up, staking claim on such interest, comma, at least, comma, the applicant ought to be implemented since the writ petition itself is still pending. First up, next para. The second issue argued by the applicant, comma, upon hearing learned counsel for the parties, comma, seems to be more arguable than the first. First up, however, comma, the situation would have been entirely different if the present applicant had come up with an application for addition of party at the juncture when no interim order had been passed in the writ petition. First up, next para, at that juncture, comma, the rights of the parties would be inchoate and nothing would have been decided or restrained by a court of law. First up, at that point of time, comma, the court might have considered the argument of the applicant to be implemented as a respondent, comma, at least as a proper party, comma, since the outcome of the writ petition might have affected the petitioner, the applicant. Full stop, next para. However, comma, insofar as the applicant is concerned, comma, the applicant has reaped unlawfully the benefit of the contravention of an order of court. Full stop, even assuming, comma, without conclusively holding, comma, that the applicant did not have any knowledge of such violation, comma, not being a party to the writ petition, comma, such stand at least renders the applicant an irregular successful candidate. Full stop. A success which is irregular, comma, is as good as being unlawful. Full stop. The success is no success if the same is in contravention of the order of the court. Full stop. In the teeth of the specific restraint order passed by the court in the writ petition, comma, the entire cause of action of the present applicant would not have arisen at all unless the tender technical bid was opened. Full stop. Hence, comma, the present application for addition of party cannot be entertained. Full stop. Accordingly, Can 7 of 2023 is dismissed. Full stop. However, comma, it is made clear that nothing in this order shall prevent the present applicant from preferring an appeal seeking leave of the appellate court in due process of law. Full stop. If such an order, such an appeal is preferred, along with such an application for leave to prefer the appeal against the interim order passed by this court, comma, nothing in this order shall prevent the applicant from moving the said matter without being prejudiced by any of the observations made herein. Full stop. Next para, Can 6 of 20, Can 7 of এটা Can
6 is
it is the other way around. I'm sorry. পুরোটা যেটা Can 7 বলে গেছি পুরোটা Can 6 হবে। না না পুরোটাই 6 হবে। 6 হবে?
6 is addition.
Thank you. Can 7 consequentially consequence. Can 7 টের now? Next. In view of the rejection of the addition of party application bearing Can 6 of 2023, comma, the present application for vacating the interim order passed by this court at the instance of the proposed added party, comma, whose prayer has been refused, comma, is also required to be rejected. Full stop. Accordingly, Can 7 of 2023 is also dismissed consequentially. No orders to cost.
Yes,
sorry, Mr. Mujumdar, but yes. Thank you. What?
That order of the past by your lordships.
Yes.
Others to मुश्किल है देखिए यदि आप नहीं चलता ना
Number 15.
My lord, this is my writ petition. My lord, on the last occasion when your lordship has taken up this matter, my lord,
Yes.
my learned senior friend was kind enough to assist your lordship with the fact that this is a shifting of my lord poles, high tension poles.
Right.
My lord, that some arrangements are being made by the authorities themselves so that the matters could be sorted out. My lord, at the bar, my lord, yesterday he had communicated that some arrangements had already been made, although there has been some objections to that effect also. But I had tried to contact my client, my lord, but unfortunately, I could not have contacted till this time.
Combined list of June?
My lord, my lord, I was
That
just
is after the vacation?
Yes, my lord, I was requesting that it could retain its position then, my lord.
Cannot. How can it? That will be a different combined list.
Yes, my lord. Since it's a pending since 2007.
No matter will retain its position in the list.
No,
because
I understand
This
that.
list goes today.
Yes, yes.
This is a supplementary list. So cannot retain its position.
My lord, by this time, my lord, we shall have probably
by that time the position may be improved also.
Yes, yes.
The list.
But this is what I have, my lord.
required. Otherwise, my lord.
Pardon?
Microphone.
Police protection in this matter is very much required, my lord, because my station manager also told me.
Police protection, no, unless it's against the petitioner, they are non-parties to this. Police protection against third parties, I cannot grant in this writ petition.
No, petitioners, my lord, we are doing the work of petitioner, my lord.
Are they parties? Police protection against whom?
My lord, against, my lord.
No, my lord, no, they are not parties.
They
we had
cannot
no-
be parties because you did not take. So I'll only on the ground of taking instruction, Mr. Banerjee, I'll It is prayed by learned counsel for the petitioner that the petitioner requires certain instructions on the.
I require, my lord, whether.
You're for the petitioner.
Yes, ma'am.
Petitioner requests certain, learned counsel for the petitioner requests certain instructions from his client as regards whether any alternative arrangement, which could resolve the dispute, has been made in the meantime, full stop. Accordingly, let the matter stand adjourned and shall next be listed in the monthly list of June 2020. Monthly list of June.
Monthly list of June, my lord, on 7th of June, my lord, if you, 7th or 8th month. I am not available on 5th month. That is the
আচ্ছা ঠিক
difference.
আছে মান্থলি লিস্ট না করে অ্যাডজার্ন টিল জুন 7th 2023 এটা জুন 7th এ থাকবে
Grateful, my lord.
থ্যাংক
ঠিক আছে?
আচ্ছা একটু দাঁড়িয়ে যান পরেরটা আমি ঘুরে এসে তারপর নিচ্ছি I'll take up the next matter after 10 minutes.
Thank you, sir.
My lord,
This
in
is
this
my-
matter, Mihir Kundu is appearing. Takes time, my lord. He has not come to the due to his illness, my lord. Kindly take up 17th
Yes, Mr.
Wednesday, my lord.
On the prayer of the, you're for the WBSCTCL?
Yes, my lord.
On the prayer of the WBSCTCL, the matter is adjourned till May 17, 2020.
I'm grateful.
Item number 17.
17, my lord, I am for the respondents, my lord, this is that matter.
Yes.
The learned is appearing, my lord, saying that his client is above 76 or 80. He could not able to affirm affidavit and all these things. So as your lordships, my lord, I would have find. Lord, just now his clerk instruct me to pray before your lordship for out of list. I do not know.
Out of list, no.
He is saying, my lord, his clerk, I do not know. As your lordship, my lord, I have.
I'll close the right for filing reply.
As your
And,
lordship.
and keep it on Monday.
Even or your lordship can open, I don't mind.
Very well. Then I'll not close the right.
Yes, yes.
Keeping in view the age.
No. I am not on that. Certainly not.
None appears for the petitioner at the time of call, although the distribution licensee is represented through counsel. Full stop. Since a submission was made on the last occasion that the petitioner is an elderly person and has certain physical disadvantages, comma, the time for filing affidavit in reply is further extended till May 19, 2023, full stop. The matter shall be listed under the same heading on in the monthly list of June 2023.
Grateful to you.
Monthly list of June, time extended till
Yes.
last. Yes.
And my lord, I have no objection. I don't.
Item number 18.
My lord, I'm appearing for the license.
I appear for the petitioner.
Yes, Mr. Bhattacharya, what is the matter?
Pursuant to my lord's direction, may I file my reply? I have served my lord.
Any private respondent?
No.
Yes, what is that?
In this matter, I have also filed an application being CAN 1, which is appearing, my lord, for certain subsequent developments during the pendency of the writ petition. May I place, my lord? I filed the instant. I will show you short, my lord. Filed the instant writ petition since the electricity authority were trying to enhance. I have given a space in my hotel premises for a transformer.
Ms. Ghosh, please take your seat.
For transformer.
Yes.
It is in the portion of the New Digha area where each hotel area is giving specific space for installation of transformer. Now, the WBSCTC's authorities approached me that they will enhance the transformer connection and give to next door, for which I came up before this court.
Give to next
door hotel, which I came before your lordship. My lord was my earlier occasion, erstwhile advocate came, where my lord has not granted leave, and accordingly they have the WBSCTCL has started. Now, my lord, there was direction for affidavits. In the meantime, pendency of the writ petition, the next door hotel has obtained a specific space wherein a different transformer has been installed to them, my lord. So there is having an independent connection. I am having an independent connection. Now, in the course of the writ petition, they have filed a supplementary affidavit saying that I am not giving access to them. I am not giving any specific space, my lord, for in my affidavit in reply, I have annexed specific photographs wherein it is shown, my lord, that kindly sees, my lord, the page photograph 6 and 7. 6 and 7. These are the portions where
This is the adjacent hotel.
Yes, they are giving. These persons belong to WBSCTCL who are giving connection to the next door. And by the if I kindly comes to paragraph page 5 photograph, this is the adjacent hotel's transformer. So they are having an independent connection, my lord. Independent transformer. But now what the WBSCTCL is doing, they are
making connection from my transformer line. That is a higher definition transformer.
No,
That-
there, I couldn't understand you.
The next door transformer is a 320 kVA.
Right.
And my is 160 kVA. Well, it's my.
Say they can give the connection from that.
Yes, no, I am not on. Since they are taking connection from the line, it's my threat, my lord, so that my transfer, because that is a higher connection. My transformer is a
So
lower.
what was your initial grievance?
My initial grievance was that they were trying to enhance the 160 kVA to 320 kVA.
The adjacent hotel.
Yes. Now, during pendency of the writ petition, the WBA-CDCL has installed a separate transformer in that portion itself, my lord. So I have stated, my lord, and it is a known fact now. So now there is no.
No, Mr. Bhattacharya, don't get your point. Initially, your grievance was that they are at their premises only, the adjacent hotel's premises.
My premises. My premises. Because the space are allotted, it is a commercial area. We have to give specific provision for installation transformer for
Your hotel is running the business with an electricity connection.
Yes.
That is being given from a transformer at your premises.
Yes.
So you are of the grievance that they are trying to increase the power of that.
My transformer.
So that has not been done. Another has been installed.
Independent connection.
So your grievance goes.
Next, my lord. One thing I am apprehending, that since the connection is given from my line only, it's my apprehension, my lord, that since that is a heavy connection, 320, my is 160, my transformer may blow out any day.
That
So
is a different cause of action.
rate them and my
Different cause of action.
and
Mr.
my lord, another thing, my lord,
That's an entirely different cause of action.
and another thing, my lord,
What another thing? I'll first answer this. That's a different cause of action.
since my lord, they have already given, so that portion does not rise today. They have already given an independent.
So your writ petition has become infructuous.
No, one thing, my lord. One thing, my lord.
What thing?
In my writ petition itself, now also they are saying that I have installed a wall. In their supplementary opposition. They have stated that during pendency of the writ petition, I have installed a wall restraining them. That is not so. That wall exists from the.
That is also beyond the scope of the writ petition. We cannot go into that dispute also.
And another.
Whatever you are doing, raise your walls, let them break that. But that is not a part of this writ petition. Because it's a separate cause of action that has been taken care of by them by installing, admittedly, and a transformer has been installed.
In my supplementary, in my CAN application I have filed, I have only prayed that the earlier position which was there, that should be maintained, my lord.
What earlier position?
That I am having an independent connection, that be continued. Let them give an independent connection to those portion.
This what do you say, Ms. Ghosh?
My lord, in this matter, Hotel Blue View effected connection on 18th April 2020.
They are Blue View.
No,
No, my lord. Another hotel, my lord.
Next door hotel.
Mrs. Hotel Beach View is theirs.
Yes, my lord.
They are Beach View.
Yes.
I am
is
Hotel
Blue View.
Jana and Company.
Jana and Company.
I am Hotel Jana and Company.
Jana
Here
and
they have
Company.
mentioned in their application Hotel Beach View.
Beach View, my lord.
Achha.
Beach View effected.
Take the microphone, Ms. Ghosh.
Effected connection, my lord, on 18th.
Mr. Bhattacharya, please help her. That-
18th
Thank you.
April, my lord.
Yes.
And my lord, from the said 160 kVA DTR. But my lord, in this matter, the both hotel connected, my lord, said 160 kV DTR. But burned the 160 kVA anytime, my lord. And my lord, this is
Don't understand. Don't understand.
instruction, my lord.
That is also my, since different transformer has been installed, the independent connection be given to that hotel, my lord. So that my transformer, my hotel be saved, my lord. Already
In
a
which
different
is,
transformer.
my lord, the augmented 315 kVA, my lord. This is my
Mr.
prayer, my
Bhattacharya,
lord.
read it out so that you can also get a glimpse of it, and I'll also understand what. Read it out for me. Read
is
it out
to-
aloud. Yes.
This is to inform you that as per the reference court order number, the undersigned along with the personnel of Messrs. MB Construction, entrusted agency of WBSEDCL, attempted to effect LT bulk connection to Hotel Beachview on 18/8/2023 in presence of police personnel of Digha PS. The said connection in Hotel Beachview was ordered to be effected by augmentation of the existing 160 kVA DTR by 315 kVA DTR installed at Messrs. Jana and Company, Marine Park. But it has been found that new brick wall construction was made in close vicinity of the DTR, violating the standard safety rules. It is to be further noted that new construction has been made through there is a steel structure fencing around the DTR previously, in such a way that for any operation of any maintenance or augmentation of the said DTR could not be possible for WBSEDCL and without demolishing the newly made brick wall construction. Also, as ordered by the higher authority in alternate way, to give a new bulk connection to Beach View Hotel, 315 kVA DTR was installed at the premises of Hotel Beach View.
So this is what you are wanting.
Yes, that has been done, my lord, already.
No, they are saying from the inside installed such and such, 2 hotels were supposed to get. 2 hotels means one, both, neither of them are you.
No, I am Janan Company. Beach View is the next.
But you are opposing to get service connection that way also, they are saying.
No,
Yes, my lord.
if in the second portion and also and ordered by the higher authority in alternative way to give a new bulk connection to Hotel Beach View, 315 kVA was installed at premises of Hotel Beach View. Said installation of 300.
No, they are saying, Mr. Bhattacharya, that because of your obstruction, that 315, although that is installed in Beach View, they could not give connection from that due to your obstruction. And that's why the new LT connection to Beach View had to be given from your premises.
No.
From your premises. That's the last paragraph.
But in circumstances, new AOTR connection in Hotel Beach View had to be installed on that day from existing 160 kVA DTR.
Then, Ms. Ghosh, you have no difficulty if a direct connection is given to Beach View at their transformer.
Yes, my lord.
So don't oppose that. I'll record your undertaking.
No, 2 things, my lord. I am having a 160 kVA transformer.
Your 160 kVA is saved if you permit them to give a connection directly to 315
Yes, my lord.
of Beach View. They'll give that connection directly to Beach View, and you'll have to remove whatever you have.
No, that wall is a safe boundary wall, my lord. That is installed since inception, my lord, because it is an open premises, my lord, in that event. I have
boundary wall has to be there.
My lord, boundary.
Kindly sees the photograph, my lord. I have.
And boundary wall, brick wall, my lord.
That was a boundary wall.
Petitioner, my lord, obstructed for.
No, their instruction says, but it has been found that new brick wall construction was made in close vicinity of DTR, violating standard electricity safety rules.
But this boundary was on page 6, my lord, just behind
my
the
lord, petition,
the person who is giving that boundary wall construct. It is 3-portion way. It's on the open road. This transformer is there in my premises.
Initially, there was a steel fencing.
No, steel there.
Fencing.
That was there was no steel fencing. This gate was there for the cattle so that you cannot enter into that transformer box area. Independent connection has been given to that hotel already, my lord.
They are not saying so. They are saying that from Jana it has been given because of your obstruction.
Kindly sees page 5, my lord. That
my lord,
my supplementary
supplementary
reply.
My lord, page number 6,
You are not
my lord.
sure on the
My
facts,
lord,
sir.
supplementary affidavit, my lord. Page number 6, my lord. Boundary wall, brick wall was made petitioner, my lord.
Due to that boundary wall, you are not being able to give connection to Beach View
Yes, my lord.
directly.
Yes, my lord.
Come to page 6 of their opposition,
Yes.
supplemented opposition.
These boundary wall existence from inception, my lord. This is because just next to that boundary wall is a reception room.
I'll refer it to the magistrate. We have to take evidence then. You have already given connection from their premises.
Yes, my lord.
That's your stand.
Yes,
That from their 160 kVA DTR, both they and the Beachview has been given connection.
yes, my lord. Only my lord, prayer, my lord, 315 kVA augmentation from 160 kVA.
No, that Beachview has asked for augmentation to 315.
315.
In Beachview already there is a transformer installed, my lord, of 315.
Now give it from Beachview. I don't understand this stand of yours.
Already, my lord. May I kindly see
My
the
lord,
Please, Mr. Bhattacharya, take your seat. Yes, Ms. Ghosh.
my lord, in this matter,
In the same breath, you are saying that 315 kVA is already installed in Beachview.
160 kVA installed, my lord, not 315, my lord. 315 kVA DDR needs, my lord.
Please come to the second paragraph of your instruction.
Yes, my lord.
Also as ordered by the higher authority in alternate way to give new bulk connection to Beachview, 315 kVA DTR was installed at the premises of Hotel Beachview. From the said installed 315 kVA DTR, the said two hotels were supposed to get service connections. So you say that 315 is there in Beachview. From that 315, Beachview can be given a connection as well as this hotel, Jana.
Yes, my lord.
But now in view of the Beachview, in view of the request of Beachview to augment the connection, their connection
My lord,
to Ms. Ghosh,
yes,
please let
yes, my lord.
there is one 315 at Beachview, one 160 at within the premises of Jana. Now previous arrangement was 160, that Jana's 160 they were enjoying from that. Because Beachview sought electricity, you gave from Jana's transformer 160. Because it's 160, that may create a hazard, which is why now 315 has been installed in Beachview itself. Your original proposition was from Beachview, from that 315 to give connection both to Beachview as well as to Jana.
My lord.
That is your instruction.
Yes, my lord, but Jana
They are
is a
preventing.
company. Yes, my lord.
So why now now Beachview is also asking for 315 for themselves only?
No.
Augmentation for what?
Both hotel, my lord.
No, give Jana's connection from Jana, which they are already enjoying,
My lord.
and let Beachview get its own connection from 315. Why should you disturb their arrangement? They have already got a 315. Please see your own instruction, Ms. Ghosh. You are not properly instructed even.
No, my lord.
What no,
Jana
my
and
lord?
Company 315.
Please read out your own instruction, the last two paragraphs.
And last,
You need not say anything
last
further.
paragraph, my lord. Under the
No,
circumstances.
prior to that, please read from the previous paragraph, also as ordered.
Also as ordered by the higher authority in alternate way to give new bulk connection to Hotel Beachview. 315 kVA DTR was installed at the premises of Hotel Beachview. From the said installed 315 kVA DTR, the said two hotels were supposed to get service connection, but MS Jana and company opposed, my lord.
No. Let it be continued. This portion, I am ready.
To get the
They
service
oppose that
connection.
from
Yes, my lord.
they oppose Ms. Ghosh. They oppose as per your instruction that connection be given to them as well as to Beachview from Beachview's transformer. That is their objection. Why do you do that? Give it. There are already two installed transformers. 160 at their premises, 315 at the other premises. So give the Beachview hotel connection from their own premises. Beachview is a party here.
No.
At order record. The supplementary affidavit in reply filed to be kept on record. Full stop. A peculiar predicament has arisen in the present case. Full stop. Messrs. Jana and company, the present writ petitioner, is running a hotel in a particular premises, where there is an existing DTR within bracket transformer, bracket closed, from which connection has been given to the hotel run by Messrs. Jana and company. Full stop. The said transformer is a 160 kVA DTR. Full stop. Next para. As it transpires from the written instruction filed today in court by learned counsel for the WBACDCL, comma, the adjacent hotel, namely Hotel Beach View, has also got installed a transformer which is of 315 kVA. Full stop, next para. The WBACDCL is of the opinion that they were of the proposal, they gave the proposal that electricity connections be given from the 315 kVA DTR installed within the precincts of Hotel Beach View to both Beach View as well as the writ petitioner. Full stop, however, comma, it is contended by the WBACDCL that the writ petitioner is objecting to the same. Full stop. The WBACDCL further contends that due to such objection of the petitioner, comma, the connections both to Messrs. Jana and Company within bracket Marine Park bracket closed and the adjacent Beach View Hotel have been given from the existing 160 kVA DTR installed within the precincts of the writ petitioner's hotel. Full stop, next para. There is no justification for such stand being taken by the WBACDCL. Full stop, since the penultimate paragraph of the written instruction filed today, which is kept on record, comma, it is evident that a 315 kVA DTR has already been installed at the premises of Hotel Beach View, comma, there cannot be any reason why the electricity connection of Beach View should not be given from the said transformer itself without disturbing the petitioner in any manner. Full stop, insofar as the petitioner's enjoyment of electricity connection from the 160 kVA transformer installed within its own premises is concerned, comma, there is no reason for the WBACDCL to disturb such ongoing arrangement. Full stop, next para. Hence, comma, WPA 28990 of 2022 is disposed of by restraining the WBACDCL from disturbing the petitioner's electricity connection from the existing 160 kVA DTR installed within the premises of Marine Park, comma, which is run by the writ petitioner, Messrs. Jana and Company. Full stop. Insofar as the electricity connection of the adjacent Hotel Beach View is concerned, comma, the WBACDCL shall make necessary arrangements within 3 weeks from date, comma, to give the connection of the said adjacent hotel from the transformer situated within its own premises, which is of the strength 315 kVA. Full stop, next para. Upon such connection being given, comma, the present connection given to the premises of Hotel Beach View from the petitioner's transformer will be disconnected. Full stop, next para. It is made clear that the time frame given in the above direction is mandatory and shall be strictly complied with by the WBACDCL, comma, if necessary, by acting on a server copy of this order without insisting upon prior production of a certified copy. Within 3 weeks, you will remove. There are two transformers. 315 is in Beach View. They have a 160 kVA transformer. They will continue to enjoy their electricity connection from their own 160, which will not disturb. And regarding the connection of Beach View, which you have given from their transformer, that will disconnect and give a new connection to Beach View from their own transformer. This entire process will be done within 3 weeks. First, you give that connection to them, yes, so that they do not go without electricity, and immediately thereafter you just disconnect this. Thank you.
Can application be disposed of?
Acha, can 1 of 2023 is accordingly disposed of as well, no rest to cost.
Item number 19.
আচ্ছা এইটা পার্ট অফ দ্য রেকর্ড হলো কিন্তু হ্যাঁ একটু লিখে হ্যাঁ কাগজটা হারিয়ে না যায়
Your Lordship, I am for the petitioner.
My
There
lord,
was a
my senior is engaged in code number 28.
Oh, what? You are there?
Seeking permission for short pass.
Who is your senior?
Mr. Subhobroto Dotto. 1990.
Your Lordship, there was a direction to file
No,
affidavit.
Mukherjee, you have no locus to appear because. Yes.
There was a direction to file affidavit in reply within 8th of May, Your Lordship. 1st of May, the order was passed. I had affirmed the affidavit within time, but I couldn't serve. I have served through email. I have the hard copies. I had requested the learned advocate to take the copy, but because I was out of time, rightly he said, I cannot. So by taking my chance, I have digitalization, I have served through email, but I have the hard copies I'll serve today, Your Lordship. If the matter could be fixed on Wednesday or Thursday, as per Your Lordship's convenience, and the matter could be
For
heard.
their convenience then. Yes.
Your Lordship, one thing, I appear for the SABC. The regulations are under challenge. I'm sorry.
Yes.
The regulations are under challenge. Now, my lord, WBERC has not been implemented as a party respondent. WBERC has to be implemented as a party respondent in the matter.
In fact, I think, my lord, your lordships, my lord, passed an order.
Yes.
Yes.
My lord, which is, my lord, yes, my lord,
Oh, yes,
17 February, page 3, at the last paragraph, my lord.
Your Lordship, we had amended the cause title. We had served them as well, Your Lordship.
Serve the WBRC.
Your Lordship, by email, we had served them.
Mr. Dotto, who is leading you?
My lord, I had
Leading
assigned.
Who is leading whom? You are leading Mr. Mukherjee or Mr. Mukherjee is leading?
We are in wrong side, my lord.
You are in the no, not that. I ask you, learned junior. I don't want to embarrass him further. Anyway. Yes. So what should I do? They have already served on the WBRC. So if they choose not to appear, then you will have to.
I'll
decide.
serve once
My
more.
lord,
Your Lordship,
I'm
if it's-
willing to, my lord, because this is covered, my lord, by Supreme Court, the point taken. So, my lord.
So should we start now? I mean,
Your
if you are ready-
Lordship, I was praying if it could be taken up Wednesday or Thursday, as per Your Lordship's.
Then
convenience.
kindly keep it after the vacation, my lord, 1 week after the vacation.
Meantime, I'll, वो तो दिच्छिलाम,
The
अपनी निजे
affidavit in reply filed today be kept on record. Full stop. The delay in filing the same is condoned. Full stop. Next para. On the prayer of learned counsel for the petitioners, the matter is adjourned and shall next be listed on June 12, 2023, Monday week after the vacation.
My lord, could it be, my lord, my lord, the 13th or 14th? 14th, my lord, kindly.
14th, very well. তাহলে June 12 না করে June 14th, 2023, full stop. The learned advocate on record for the petitioners shall serve further notice to the added respondent, that is the WBERC, in the meantime indicating the next returnable date.
Obliged.
Thank you.
Item number 20. The affidavit of reply may be kept on recording.
Resolved. Not resolved.
I just told Mr. Chaudhary, my lord, every time he appears, my lord, he wants to resolve it. So, my lord, he
Yes,
should only.
fair enough. And every time you appear, you don't want to.
Doesn't get, my lord.
By necessary exclusion that.
But, my lord, he fails. That's what I'm saying. My lord,
No,
he
not
tries to
always.
resolve
Not
it.
always. He succeeded in 1 or 2 occasions.
Only when I'm on the other side. Otherwise, no.
Well, we have not received any proposal from the.
We will hear the matter.
There is no answer.
That's
No,
why we
but you didn't receive any proposal.
Yes, but we couldn't get our clients to agree.
Your client did not agree. Sorry.
The proposal to page, yeah.
No, we didn't get the
No, we didn't get the proposal actually.
But, with my
Yes, yes, the
seniors
proposal.
leave, my lord, they had indicated if you want any proposal to be considered, give it in writing, because otherwise.
Yes,
it's an
obvious.
authority.
Right.
So, my lord, we placed a proposal to our client, requesting them to agree. For financial constraints, they were unable to agree, which is why, my lord, it could not go through. We are back to where we were, so we want to press. My lord.
Then we'll hear the arguments. Right. Yes, sir.
Well, the issue really is, my lord, that whether, my lord, or rather, the first issue, my lord, which we want to urge is, my lord, that DPS, there can't be DPS, my lord, without there being, my lord, a fixation of, my lord, the tariffs. Here, my lord, it appears from the records, my lord, I'll show that Malad, the 24.33 crores, Malad, about Malad 10 crore 72 and Malad 13 crore into which
that
Malad is Malad DPS which is charged from 2009 to 2013. Malad, there is a settlement Malad of Malad 30th September 2021, which was Malad before Malad arrived Malad before the Honorable the Appellate Court, the Division Bench. And Malad, there we had agreed that 56 crores Malad will be paid in installments. Now the issue is Malad, if we are held to that, then Malad, what happens to this 24 crores? Because now Malad, from Malad's judgment Malad, which is Malad pending in appeal Malad, as I understand, Malad is held that before there is finalization of tariff, there can't be any DPS. Now, if that's the position in law, then Malad, whether the settlement which we had entered into prior Malad to the order of Malad 24th January 2022, which is my Lord's order, Malad, we are bound by it or not. This Malad really Malad, as I Malad saw Malad, becomes Malad really Malad the issue. Because there are the two orders, Malad, they say Malad the point which they have taken, and I don't think Malad there's much dispute, or at least Malad from the affidavits, I did not find Malad much dispute, that Malad 24.33 crores is by way of DPS, which is charged Malad from the period from 2009 to 2013. They have Malad really Malad in the affidavit come up Malad with 3 points. They say first, that because you entered into a settlement of 30th September 2021, it's barred by res judicata. Secondly, they also take a point that Malad, we had filed an earlier writ petition, Malad, that was 24866, Malad, something like that, before my lords, where Malad directed us Malad to go and Malad again Malad consider, and Malad the question of Malad consideration of Malad the secure deposit. That is also having raised a not.
Is that matter 56(2) bar comes in?
No, no, no.
No, not that.
No, Malad, that is Malad.
That is all.
Shito argued. That's just reserved. Yes.
Well.
Malad, I think, but the principle, Malad, in the question of Malad DPS, Malad, I'll show Malad's judgment, Malad, on the
I'm
question
prepared
of
with the
DPS.
written notes of arguments, Mr. Banerjee, whichever day you say. It will cut short the arguments.
Malad, we'll get ready, Malad, on the, but Malad, I want to show Malad certain
No, you will show the
questions.
You can start today also, yes. So let us start the hearing.
Opening it up. বুধবার পারবো না জাস্ট রিওপেনিং এ রেখে দেন ও খুলবে না অনেক ঝামেলা
Now Malad the settlement is happening. Now Malad, if I step back Malad, now Malad the settlement is happening.
Anytime.
Malad,
মানে Wednesday it's not possible. Man, let Mr. Banerjee make his submissions. Man, kindly allow me to make submissions on reopening matter. It's very difficult. Yes. In fact, man, Mr. Chaudhary had concluded the submissions.
He had probably.
Man, then my lord, let Mr. Banerjee conclude his submissions on Wednesday. Man, kindly keep my submissions after vacation. Subject to lordship.
Instead of piecemeal, then I'll take up after the vacation.
Just after vacation. If it suits them.
Then I'll take it up after the vacation. If he can't be ready before the piecemeal, I'll hear you and then it will again be relegated to after the vacation.
Correct.
What is the urgency here, Mr. Banerjee?
Malad, reopening of Malad our factory, Malad, if you're successful,
That.
because if that 24 crores Malad is given credit to us, then Malad, quite naturally Malad, there is Malad that demand of Malad security deposit of 18 crores Malad, and the rest Malad doesn't Malad come in.
Please exchange your written notes. Please just propose written notes. Please exchange between yourselves and come back on after the reopening on any date which suits both of you. And we'll just cut short this, indicate the points in the written notes, cite your judgment.
It is, that's why Malad, so far as Malad, I'll also Malad, I don't know, Mr. Chaudhary Malad must have argued Malad these points only. These are
You want
Malad
to
really
do that today, you can start today also.
These are Malad really Malad the points. No, Malad, we'll come back Malad, and I think it's best that
You can start your arguments. I can conclude your arguments before the vacation and they'll come back after the vacation. No, whatever you choose. That will save further time. Oh, no, I don't want to keep it parted before the vacation. After vacation, come back. After vacation.
No, Malad, then we'll start.
No, please don't. No,
Malad
please
is
starting.
So far as my submissions are concerned, man, kindly keep it after vacation. Man,
Piecemeal, Mr. Chaudhary, no.
Man, let it be heard in part. Man, the parties are
Yes, kindly
agreeing.
Malad.
The parties are agreeing.
Malad, it's a
Man, we are agreeing.
I am not.
Man, kindly.
I don't know why you are unnecessary.
Kindly make it heard in
Unnecessary
part.
part.
Man, for the
We
interest
don't
of-
know, Mr.
Malad has actually Malad heard this. Malad,
Your lordship has
already
heard this
I can
substantially.
also Malad make my. tell my lord why, my lord, what, my lord, we are, I also got the judgments also, my lord, today. Absolutely.
There's a chance of settlement.
My lord,
Mr.
your lordship
Banerjee,
has,
so
my
there
lord, one matter your lordship has heard in part and decided, and now judgment has been reserved. This can be done so.
My lord, perhaps,
similar matter.
No, the DPS matter.
That is a different matter. So what?
My lord,
That is the reason I'll not part.
my lord,
make
so
this
my
part.
lord, it is possible that your lordship can hear the matter in part and keep it heard in
my lord,
part.
Not possible due to that other CAV matter.
No, which one?
Which one you
That-
referred to?
No,
The
no,
one you
my lord,
referred to.
that is true. My lord, what
No,
we
come
are-
back after the vacation. For part piecemeal
Part
hearing.
heard here.
my lord, I can finish my submissions today, my lord. No, my lord, put that offer.
So why can't you come
Give
back
it
on
to me, my
Wednesday?
lord.
Well, difficult, my lord.
Why difficult?
My lord, the matters are already fixed. That is why.
Thursday karo.
Thursday fixed.
No piecemeal hearing, Mr. Banerjee. Come back after this. Let it count. Yes.
I can, my lord, finish my arguments. My lord. It's actually, my lord, a very short point. If my lord has already, my lord, I think, my lord, what I've submitted, my lord,
Then come
is
back
really
on
the point.
Monday. Why Wednesday?
Why, that
Monday,
is, my
come
lord,
back on
really the
Monday.
point.
You have got a
Monday,
weekend.
Monday is a PIL day, my lord.
Monday,
Monday. My lord, kindly hear it in part, my lord. The part,
No.
there is no difficulty, my
Not
lord.
carry over after there are too many parted matters. Sir.
Well, I'll
Unnecessarily
take-
parted. No. Just to
This is
make it
actually
parted.
part.
That is right. My lord, in fact, my lord, from what I heard, my lord, it is actually
It
part.
is actually part.
My lord, without
My lord, Mr.
Okay,
Chaudhary
finish your
made-
arguments today. Very good. Mr. Banerjee. Start.
Very well, my lord. I'll just.
Very good.
It's
My lord, I make my submissions immediately on reopening. The
I
first,
can. I don't make my promise on that.
my lord, on the
After hearing
reopening
him, I'll
day,
decide.
or on the reopening day itself, I can.
I may insist that your junior starts. I don't know.
But today it is very.
I cannot give you any word of mouth. No. Let us start the hearing today. It is substantially heard, you say.
It has been substantially heard. Mr.
let me
Chaudhary
continue with
made
that
his
hearing.
submissions. Mr. Chaudhary made his submissions.
Now, Mr. Banerjee will make his submissions, naturally. And he'll finish today. If he finishes today, you can start today also.
The judgment is.
My lord, today I can start definitely, but my lord, there are matters, my lord, which will clash in the second half, my lord, to be very candid before your lordship.
Wednesday, you have a difficulty.
Then, my lord, let us do one thing. My lord, let us do one thing. Let Mr. Banerjee conclude his submissions today. I come back on next Friday and make my submissions.
Next Friday, very
Yes, next Friday.
The last day.
And I'll ensure that both sides are present when you make your submission next Friday. I'll keep it at say 3.
Yes, that would be absolutely fine.
Right.
Well, that is why, Mother, kindly, Mother, kindly make it heard in part and kindly keep
You
it.
cannot
after.
have it both ways.
No. We are agreeing, Mother. So far,
Agreeing to what?
Mother, kindly make it heard in part and kindly reopening. We are agreeing, my lord. The parties, man, we can even make a request to the Honorable Chief Justice.
No,
that
don't.
Your lordship has heard the matter substantially.
Better to argue. Start arguing.
Mother, kindly keep it heard in
That's a
part.
sufficient threat.
Mother, kindly make it
Let
heard
me
in
hear
part.
Mr. Banerjee. I cannot
Lord, kindly keep-
commit now.
Lord, our request is also, Lord, it won't take much time. Lord, before my lord, it won't take much time. Whenever my lord, my learned friend wants
Mother,
to
kindly
come
keep
back,
it heard in
so that-
part.
so- think the point.
Then make your arguments today. You finish your arguments today. You'll file a written notes on the reopening, and they'll make their
Yes,
arguments and
yes,
file the
yes,
written.
yes, that can.
You can hand them over the written notes of arguments
yes.
before the vacation,
That-
so that he can come prepared, and I'll keep it on a day after the vacation. He'll conclude and file his written notes on that day.
নেই সোমবার।
Lord, if my lord comes, my lord, just my lord on the fact, my lord, just give me one. My lord, one. My lord, the dates, if my lord looks at, my lord, the dates, my lord, first, my lord, is on the question, my lord, the 24.33, my lord, crores, my lord, which we say, my lord, is on account of.
Have you got a
DPS.
list of dates? Short list of dates?
করা উচিত ছিল ভাই, সবসময় তো আমরা বলি না, ওখানে থাকলে কি করে হবে? That's not really- ওই notes এর সামনে আমরা একটু চলো। We'll give Malad a very short list of dates as well. Malad, there, if Malad
That is
kindly
why we
comes to-
come back after vacation, man. If your lordship
Come back after the vacation. I'm telling you to
all
do
of
that.
us come back after vacation. I think that will be better. There will be no piecemeal hearing. Kindly make it heard in part, and we come back after vacation.
Apart
I
from
think Mr. Banerjee would
apart
agree.
from one of your submissions, I agree to the rest.
So, my lord, kindly
Malad,
make
on the first day, Malad, can we-
first day
First day of it.
reopening day, 10:30 reopening day.
Oh, 10:30 reopening day, both of you will be here.
I will be
Yes,
here. I will be here.
Very good. Then I'll keep it.
Yes, my lord. Kindly, my lord, heard in part, my lord.
He has to start the hearing then.
But Mr. Chaudhary has made submissions. Your lordship has your last order records No, last offer records. Records that.
It's heard, my lord, it's heard.
It heard.
In fact, I had also made
Mr.
submission on the first.
Majumdar, it will appear as if just to keep it part of.
No. My lordship has heard the matter substantially. I think Mr.
Even in fact, my
also
first day, I
said-
had also submitted.
Very good.
On the
Yes.
first day, I had also submitted, then I was.
Let us come back to your lordships, then whatever happens. Yes.
Very well. Heard in part for further hearing on
Fifth.
further hearing, the matter shall be listed in the monthly list of June 2023, which will be on the reopening.
Yes. Heard in part.
Yes, heard in part.
Heard in
আরেকটা ইয়ে করে learned counsel for the parties are requested to file the written notes of arguments on the next date of hearing. Please exchange your brief notes and then just come prepared with your,
Yes,
both of
that's
your
exactly
written
my
notes.
lord.
My lord,
Will
only
be
one
cut
thing, my lord,
short.
my junior insists sixth. I have no problem, sixth. I have no problem.
It will be on the combined list. If he has any
Yes,
difficulty, ask him to make.
Yes. Heard in part হয়ে যাচ্ছে, আর কি আছে?
বলবো তো,
Yes.
আমি বলে দেবো,
So we have convinced your lordships.
It would have been finished by now, probably, the hearing itself. হয়ে গেছে, পরেরটা।
I take your lordships.
Thank you. Yes.
Grateful. You.
Number 21.
21.
I appear, my lord. My lord, I will request your lordship not to take up after vacation since I'm not ready.
Readily granted, readily granted.
I'm not ready.
On the, you're for the petitioner, can I record that?
I'm for the petition.
On the prayer of learned counsel for the petitioner, the matter is adjourned and shall next be listed monthly list of June. That is the reopening. Listed in the monthly list of June 2023. Thank you. Never listen to Mr. Mukherjee.
If he has problem on the fifth, so he doesn't want.
No, if any difficulty is there, I'm just ask for it. I always somebody appears and asks for adjournment visa generally.
I agree with you, lord. That's why I said nothing.
No issue. Let it be in the combined list so that it will continue in the list if
He
necessary.
is saying because he has difficulty on the fifth, that's why he is trying to point out. So let it appear in the month.
Deeply obliged.
Item number 22.
Sorry.
Item
Yes, Mr.
number
Das, what is the matter?
My lord, my affidavit in reply, my learned friend had served me a opposition, copy has been served upon.
My lord, this is our affidavit of opposition, my lord, he has served it day before yesterday in the evening. A new chapter has been opened by him. Because
Close
he
the
is not-
chapter today.
He is saying that he has not purchased the building at all.
No,
And it is not belonging to him.
but that is all along my case.
One second.
Yes, Mr. Haldar?
You have a question of 5 to 7, my lord, this is my lord.
But I have given a reply to that as well.
Very well, I have asked for clarification one day because yesterday I have.
So you had filed your opposition previously?
Yes.
Today I'm filing. Because in reply I am.
Oh, opposition you are filing today?
I am in reply I find that they are saying something else which is not.
I have got the opposition on behalf of respondent numbers 1 to 3 and 5 and 7.
Yes.
So these two oppositions are there, reply 2 sets of replies.
Two sets of
I want, my lord, if lordship be kind enough to take it on Monday. Because one day I will take clarification.
My lord, what is the clarification? My lord, that is my case in the writ petition that I have purchased vacant land. Thereafter, my lord, there was a room in which I am effecting electric car.
Sir, when I take instruction, come back after the recess then.
After this is.
I
They will go to the spot. They will they will take inspection whether there is any building or not, or where they want.
You're trying to kill time, sir.
My lord,
Because you're not ready in the matter.
my lord, kindly.
This is not fair.
One day, lordship, what time I will take?
But again, my lord, a new chapter will be opened up. in this matter.
Monday may be a busy day because several matters have been fixed on that date also. No, so
I will do it.
start today. Why not today? What is the difficulty?
My lord, may I just say something?
Everything is there on record.
Yes.
You have filed, they have filed, you have filed your reply. I mean, they have filed their reply and you filed your.
In reply, what they are
But
saying.
that is not my case in reply. That is my case in the writ petition as well.
My lord,
My lord, may I say this?
very well.
Now, my lord, the total land was 16 decimals. My lord, 16 decimals belong to the Janas. My lord, Janas sold 10 decimals out of 16 decimals, my lord, to my lord, the Deepak Kumar Mal. Now, my lord, Deepak Kumar Mal,
Marketed or
my lord, demarcated, absolutely demarcated. There is a registered date, map, plan, demarcated 10
all the
decimals.
Janas sold.
All the Janas sold to the Deepak Kumar Mal. Now, my lord, Deepak Kumar Mal had 10 decimals of land. Out of 10 decimals of land, Deepak Kumar Mal kept 3 decimals for himself and sold 7 decimals demarcated vacant land, my lord, to this petitioner. Now, my lord, in that 3 decimals which Deepak Kumar Mal had, Deepak Kumar Mal's house was over 2 decimals, 1 decimal of land was vacant, and the 7 decimals which he sold, in my writ petition, it is my case, it was completely vacant. I purchased vacant land. Now, my lord, in that vacant land, there was a temporary structure. My lord, only that was a temporary structure, not a permanent one. I prayed for effecting electric connection there. Now, my lord, the ACDCL says that Deepak Kumar Mal's father, Purno Chandra Mal, my lord, he had some outstanding dues in his name in respect of the premises of Deepak Kumar Mal. And now, my lord, since there is outstanding dues in the
That
name,
was prior to his sale to you.
that is much prior to the sale. My lord, I purchased it in 2022. Now, my lord, they say that since there is outstanding, we cannot give you the electric connection. My lord, that is the order at page 49.
So you say Deepak Kumar Mal is still the owner, exclusive owner of a portion.
But Deepak Kumar Mal presently has died. The private respondents 5, 6, and 7, they sold the property to me. 5 is the wife, 6 is the son, 7 is the daughter.
So they are still the owner of 2.
They are still the owners of 2 decimals of land containing the building.
They have to claim from them.
They have to claim from them. And my lord, with me, so far as nexus is concerned, my lord, there is absolutely no nexus with me and Deepak Kumar Mal.
All right.
My lord, kindly sees, my lord, page 49, that is the letter. And the letter also does not speak of any nexus between me and Deepak Kumar Mal. Now, my lord, if your lordship takes up the opposition of, my lord, ACDCL. Now, my lord, in the opposition, my lord, ACDCL has come out with a new point, which your lordships, my lord, for which my lord, lordships wanted my lord, them to file an affidavit. My lord, I have annexed my deed. Now, my lord, kindly comes to my lord, my paragraph in the writ petition. Kindly comes to paragraph 7. Your petitioner states that subsequently, by the passage of time, the legal heirs of Deepak Kumar Mal, since deceased, on the basis of a deed of conveyance being deed number such and such, dated 1st April 2022, as against valuable consideration, sold, transferred, conveyed 0.7 decimals of Bastu land out of 0.10 decimals. So, my lord, my case is I had purchased the land, and that is why, my lord, my deed kindly comes to my registered deed of conveyance. Well, my registered deed of conveyance, my lord, starts from, my lord, page annexure P2, page 28. My lord, this is, my lord, executed in my favor by Konika, Moinak, and Devayuni. And my lord, kindly sees the schedule. I have annexed the map and plan. It only says land. My lord, my learned friend's contention was that I had purchased the land and structure. If I had purchased the land and structure, then in that case, the valuation would have been 97 lakhs odd. My lord, land shows 65 lakhs. So, my lord, I have acquired benefit from them. So, I am hit by the provisions, my lord, 3.6 point, my lord, of the Electricity Regulatory Commission Act. Now, my lord, in their affidavit in opposition, my lord, kindly comes to their stand, my lord, annexure R1, page 2. The electric meter was in the name of Purno Chandra, who is the father of Deepak. Purno Chandra died in 1996. Deepak died in 2019. And my lord, in their nexus tree, my lord, they are not able to show a single thing as to how, my lord, they are able to establish that I have any nexus, any relation, or I have acquired any benefit, my lord, from it. My lord, my deed, which is, my lord, annexed to my deed petition, I have annexed the map and plan. It is a completely demarcated land surrounded by a boundary wall, page 33. Now, this is plot number 580.
Yours is plot number 580.
580. And my lord, pursuant to that, my lord, I have also recorded my name my lord, the LR record of rights, my lord, bears my name as the recorded owner. And in their affidavit in opposition, my lord, kindly comes to one paragraph as to how they are trying to establish the nexus.
Your portion is also marked as a Bastu land.
Bastu land, it's a land. My lord, I had purchased a land. Now, my lord, kindly comes to their averment, my lord, in their affidavit in opposition by the ACDCL, my lord, paragraph 6.
Yes.
It is further stated that the petitioner purchased the property, that is land of 7.66 decimals and building thereon. But I have never purchased the building. 2-story, but the petitioner annexed the deed of conveyance in respect of land only showing valuation of rupees 65 lakhs without showing or disclosing anything about the structure thereon. From the requisition obtained from the concerned office of the government in the form of a query dated 24th April 2023 for the land and structure, it is revealed that the value of the land is 65 lakhs and the value of the building is 32.67. I have purchased on 65. The petitioner did not produce any document showing that the purchase the building valued at rupees 32.67 where new connection is asked for. That the petitioner on the face of record has purchased the land and the building showing less valuation and thereby has benefited to the tune of rupees 32.67 lakhs. But it is neither here nor there, because my lord, it is not their case. It is, my lord, kindly sees the way in which I have dealt with this paragraph in my reply. My lord, paragraph 6 in my reply kindly comes to my lord, internal page 13 of my lord, reply, my lord, small Roman 5.
Internal page?
My lord, 13.
Achha.
My lord, kindly comes with reference to the statements to contentions to allegations made in paragraph 5 to 9
Yes.
of the said affidavit in opposition and its connected annexure R4. I deny and dispute the statements. I say that since the respondent numbers 5 to 7 herein had only sold me the vacant part of land at measuring 0.07 decimals. So, my lord, I have never purchased the land, and my lord, as on this day, and I can produce the pictures if your lordship desires.
In the body of your sale deed, it is mentioned as a land.
As land. And my lord, this is the nature as on date.
That I'll not look into.
Lordship.
I'll not look into that. From the descriptions in the deeds,
It is a
whatever is
description
there.
in the deed, it is land, and I stick to my argument, my lord, saying that till date, my lord, it is a land. So, and my lord, so far as the question of nexus is concerned, my lord, they are not able to establish any nexus between me and the respondent numbers 5 to 7. So, my lord, if there is any liability accrued, my lord, the private respondents are till date in occupation of that residential house, building. My lord, they are still in occupation of 0.03 decimals. So, my lord, if there is any due recoverable, my lord, that is to be recovered from the legal heirs of Purno Chandra Mal and Deepak Mal, which is the private respondent numbers 5 to 7 here. And my lord, this letter, nowhere they have stated that it on the ground of nexus, my lord, this can be refused. And my lord, I had produced a judgment of the Honorable Division Bench, my lord, before your lordships. My lord, in that judgment, my lord,
yes.
my lord, kindly comes to, my lord, I shall just only, my lord, for the purpose of, my lord, in this judgment, my lord, kindly comes to paragraph 7. এটা হচ্ছে স্যার 2023 এসসিসি অনলাইন কপিটা দিয়ে দিচ্ছি। এটা হচ্ছে ওয়েস্ট বেঙ্গল স্টেট ইলেকট্রিসিটি ডিস্ট্রিবিউশন কোম্পানি লিমিটেড ভার্সেস ট্রান্সমিশন এন্ড ডিস্ট্রিবিউশন ইন্ডিয়া। Now, my lord, listen.
This was cited on the last occasion.
I was cited. Kindly comes to paragraph 7.
Yes.
My lord, one has to establish the nexus.
Has to.
Has to. My lord, without establishing the nexus, they cannot deny me, my lord, the supply. But these are my submissions.
Yes, Mr. Naik. My lord, why are you saying they have taken a stand that they have not purchased the property? They have purchased the property.
No, they are saying they want connection in a temporary structure where they were residing. Where they have said so. Where is the temporary structure, and they are saying 03 decimal where the structure is.
The deed, the document or the deed shows that they have purchased a land, demarcated land.
There is no structure. at
There is
all.
no mention in the deed of the structure.
They are suppressing that part, Lordship. We are showing by the giving photograph. There is building having 1200 square feet each floor. He is talking about that his structure was there on 0.03 decimal.
Mr. Nayak, when he purchased, if in the deed no structure is mentioned at all, then he could not have purchased a structure.
Yes,
If he could not have purchased a structure, he might have subsequently built a structure there. Who prevents him from doing it?
on March they sold it in December. In March,
How can you ascertain from the photographs that
they
this
are
is a-
saying they are staying there earlier. They are
Let me see your photographs.
yes, yes. That's the thing, my lord.
Which photograph, Mr. Nayak?
I wanted to, my lord, to have it, my lord.
Show me the
confirmed.
photograph.
In our affidavit, also, can you see?
Page 20.
My lord, page 20. This is, my lord, 1200 and 1200 structure is there on the plot, we are saying. On the same plot, my lord. And our estimated, our requisition also, my lord, said so.
First of all, Mr. Nayak, nothing in this photograph indicates that it is on his plot or your plot
Lots of
or
times-
my own plot.
My lord,
So
that
we cannot ascertain from this. One. Secondly, there is no hint even of nexus. You cannot improve
That-
your case
that part I'm-
subsequently in affidavit.
that part I'm coming, lordship. I'm not on nexus, factual part. What the reality? He wanted to have connection. He want to connection.
Nexus
on a
is the only part we can look into. 13.9
No, my lord,
says
on a
nexus.
vacant land, we cannot give connection. He will have to show where we.
That
he
is
wants-
never. Did you take that point in your reply?
Yes, they want to have take
Show me
connection
that.
in the building.
No, in your communication to them.
Yes,
That
lordship.
is
Kindly,
page
kindly,
49.
kindly.
Only you said outstanding page
Outstanding.
49 of the writ petition.
My lord,
Only outstanding dues at the said premise. On that
Said-
score, you are saying no, it's not possible.
my lord, due to the above, my lord, we have stated in our the application number such and such for new service connection. This is to inform you that quotation of service connection in the name of.
Where are you reading from?
My lord, page 49 of the
Yes,
writ
right,
petition,
absolutely.
my lord. And the outstanding dues at the same premises where connection has been applied for. This is the stand. This is the.
This is the only stand taken by you.
My lord,
We
have
cannot
said-
improve that now.
I am not improving, lordship.
You are
I am
saying there is no structure. How we
in
cannot.
the same premises we have said so.
No,
Now-
they are saying they purchased the land without structure. But subsequently, what they have done, whether any temporary structure is there, we cannot go into that question. You have not taken that question before them.
No, my
You
lord.
did not refuse on that ground at all. You asked for outstanding dues. I'll allow the writ petition say no outstanding dues can be claimed by you in the absence of any nexus being pleaded or proved.
That part I'll argue, my lord. I have not argued it. Also, kindly see our inspection report, my lord, which is government document. Kindly come to that. This is the dated
Page.
at page, my lord, in our opinion opposition, page 27. On 26th of April, we have obtained it. Page 27.
Yes, Mr.
Now, my lord, here, kindly the second table, my lord, below table, L1 and L2, two plot, 7 point something, my lord, decimal, 7.666 decimal, 65,000. Now, my lord, on the same plot, kindly turn it over. Structure detailed, land L1 and L2. Kindly turn it over, page 28. At the top left-hand side,
Yes.
land 1 and 2, on that, my lord, it is the 2400 square feet structure is there, my lord. This is the government record. We may not have anything more than this. Therefore,
You
over,
say L1 and L2 covered. L2 is theirs.
No,
yes, L1 and L2 also kindly come.
no, they have given the name of the owner as
One second,
Konika.
please, one second, please. Name immaterial area.
How are they connected with L1 and L2?
Left-hand side, Lord, say page 27. They have shown L1. L1 is air plot number 580. LR 421 and
Abhinandan Manna is their client.
Yes.
yes.
So they applied for this information.
No, we applied for. Our
Then how can the
a-
applicant's name be Abhinandan Manna? Why did you give the name of the applicant as Abhinandan Manna?
Yes.
1 second, Lord.
Majkane. Seller details.
Abhinandan Manna, my lord, this applicant's name and address.
They did not apply.
No, we, at our instance, we have done this.
In his name?
How
That
it
was
is-
practicing fraud, Mr. Naik.
How it is done, my lord, I will have to, I cannot clarify even then.
You cannot clarify, who can? You are appearing for the WBACDC.
Yes, lordship. 1 second, lordship. We don't know one now.
Naik, not even a single matter WBACDC is coming out scot-free. Not
No,
a
no,
single matter.
this is not simply information from the record. I do not
Your
know where
tone
the
of
right-
voice cannot change the seriousness of the allegation, Mr. Naik.
My lord,
You may take it very lightly, very loosely, but it's a very serious offense. How can you apply in their name for certain properties which may not belong to them? This is annexure P R4. Let us see how you have referred to it in your opposition. Which paragraph? Where you have referred to it, Mr. Naik?
I have referred, lordship, here at page 4, my lord. That is at paragraph 8, page 7.
A copy of the query obtained. You obtained the query from the government in their name.
My lord,
That presupposes some false play. Presupposes.
My lord, our officers went there, wanted to have, my lord, the valuation, land valuation. What is the valuation of this?
In his
That-
name, how could you apply?
My lord, how it was applied, how was allowed, my lord, that I cannot, my lord, justify right now.
No
But
question
perhaps-
of their allowing. How did you apply in his name? What is your locus to apply like this? And this is not fraud, then what is fraud, Mr. Naik? You apply in his name,
My lord-
say that it's his property, his application, he asks for the valuation.
No.
You get the valuation, you annex it boldly to a pleading before the High Court, and you're now coming up and saying you don't know.
No, no, I'm not saying, my lord, how it was, why it is written. Why, my lord, Abhinandan Mannal's name is written there in the name of applicant's application name, address and others, applicant's name.
How could they know the applicant's name even? I mean, their name.
That was in the petition, lordship, they made application because he is saying they have.
They made this application and annexed to you, annexed to your opposition.
The deed is there. From the deed, we are finding his name. Now, my lord, that should not have been written.
Applicant's
should have
name
been-
is his name.
No,
How could you apply in
applicant
his
should-
name?
applicant-
Explain that to me first.
Applicant's name should have been, my lord, our officer's name. Because he went there. He made this application to have this information.
Court not only cannot rely on this, Mr. Naik, you are producing a document which is fraudulently obtained.
My lord, obviously, he identified himself.
Can I
before the-
apply in your name? Just because you are an institution, you are the WBACDCL.
Now these documents are from land.
You are boldly arguing in favor of your client.
No,
It's ridiculous, Mr. Naik.
not on that.
What state of affairs you have come to?
My lord, now
An advocate of some practice is boldly relying on his act.
my lord, what I
Mr. Naik, you should be ashamed. Your head should hang in shame. In each and every matter, fraud is being practiced. You have applied in his name. I'll initiate 340 proceedings against your officer. In this matter, there should be one example at least where it is done. This is 340.
my lord,
No. Why not? Why not? Tell me why not?
my lord, I tell you, lordship. Now, my lord, the land information is available from also, my lord, this Bhumi webs. Whose land it is immaterial, but we can have the my lord records also and information. Nowadays, it is, my lord, on record. Everybody sitting here, I can have, my lord, information from what is the land value, whose name is this, and how it is.
So what?
So we can have it.
Yes.
It is not that, my lord, I cannot have somebody's information, land's information.
Not in his name.
That application should not have been made in his name.
I'll inquire. I'll initiate a 340 proceeding. That is what I'm giving you notice regarding. 340 proceeding regarding this fraudulent document. How could this be obtained by your officers in his name?
That name should not have been written, but document is available, lordship, always to everybody. Everywhere. I can have, anybody can, my lord, have my land information sitting here.
Naik, are you pretending or you are really
No,
not
not
understanding the implication?
But
You really not understanding the implication of this? I can write a check in your name and you will go and say, yes, The name is wrong only. The check is for everybody can, anybody and everybody can sign a check. So I have signed in your name. So what? The name is only wrong. How could you obtain this information? And you are pressing it in court. In his name, it has been obtained. You didn't even check this. In every matter, this will be committed.
I have not checked, Lordship, because it is very, time was very short. Therefore, I could not really check it. I tender apology if that that was
Who
my
is the
mistake.
responsible officer asked him to be present in court tomorrow? On Monday. He'll be present in court. একটা order record করুন তো।
Lordship, one small submission.
একটা order record করুন।
But before
এদিকে আসুন,
that,
এখানে এসে record করুন। Learned counsel for the petitioner argues that no nexus whatsoever between the petitioner and the alleged erstwhile defaulter in respect of a meter has been established or even pleaded by the WBSCDCL. Full stop. Next para, it is submitted that although the WBSCDCL, in its affidavit in opposition, has sought to disclose a document purportedly relating to the valuation of the property, the same has no connection with the petitioner. Full stop. Next para, it is submitted that on the strength of the deed of purchase of the petitioner, it is clearly evident that the purchased property was a land and there was no building thereon. Full stop. However, the valuation which has been shown in the annexure to the affidavit in opposition pertains to a structure as well. Full stop. Next para, learned counsel submits that mere production of such valuation cannot be an indicator of any nexus between the petitioner who purchased the property from the heirs of the alleged erstwhile defaulter, with whom the petitioner had no connection whatsoever. Full stop. Next para. It is seen from the affidavit, heard learned counsel for the WBSCDCL who places reliance on an e-assessment slip annexed to the affidavit in opposition of the respondent numbers 1, 2, and 3. Full stop. It is submitted that from the said slip, it is clear that the valuation of the property was much more than that shown in the sale deed of the petitioner. Full stop. Hence, a presumption of nexus can be drawn, as the petitioner must have purchased the property at an undervalued rate due to the electricity dues pending at that juncture. Full stop. Next para. A bare perusal of the purported e-assessment slip annexed at page 27 as annexure R4 to the opposition indicates that the name of the applicant and address details are those of the present writ petitioner, whereas in paragraph number 8 of the opposition, the respondent numbers 1 to 3 have boldly stated that the query that has been annexed was obtained from the government from the land and structure. Full stop. Next para. The document, prima facie, at least prima facie, seems to have been fraudulently obtained, since the name of the applicant was of the petitioner, whereas the document comes from the custody of the respondents, who have annexed the same, pleading that the same is a query with regard to the petitioner's property. Full stop. Next para. Hence, the officer responsible for obtaining such information slip shall be present personally in court today on May 15, 2023, when the matter shall next be listed. Full stop. Next para. Such explain how the WBSCDCL could apply for an e-assessment slip with regard to a property in the name of the present writ petitioner, behind the back of the writ petitioner, and without the writ petitioner having any knowledge whatsoever of such application being made. Full stop. Such inquiry acquires relevance since the said document is the exclusive document which has been relied on by the WPACDCL for the purpose of asserting that the petitioner had a nexus with the erstwhile defaulter. Full stop. The WBSCDCL has sought to make out that the plot numbers involved in the information slip are those belonging to the petitioner. Full stop. Next para. Let the matter stand adjourned till May 15, 2023 for such purpose and for passing further orders. The affidavits in reply filed today be kept on record.
My lord, he will certainly be here. Only, my lord, two other things where I have not placed. Because
Call on the next matter, please.
my lord, only on Nexus, my lord was pleased to observe this, but two other things were also there, lordship. So it is on fixed on Monday, lordship?
Yes.
No, Monday no kabe holo.
Achha. Affidavits in opposition as well as reply filed today be kept on record.
So, my lord, Monday at what time, lordship? At 10:30? What?
Mixed matter supplementary list, 1.
Yes, what is it?
I am for the petitioner.
Who is for the other side? Mr. Mukherjee is there. Yes.
Lordship. In this matter, Lordship,
Please take the microphone.
Lordship, respondent electricity authority with the help of police, Lordship, continue electric connection, high voltage electric connection of about 20,000 watt, which is Lordship 20 kV, adjacent to the residential houses of the petitioner and also other 100 villagers, Lordship. Then, Lordship, villagers including petitioner protested. Thereafter, respondent electricity authority supplied copy to the petitioner and told that they are performing their duty. Lordship, this huge voltage line may affect the life of the petitioner and others villagers, Lordship. Lordship, this respondent electricity authority, in violation of 68 and 54 of the Electricity Act, permitted the petitioner, private respondent, Lordship, permitted private respondent to give this high voltage electric line, Lordship. Kindly see, Lordship, page, kindly see section 68, Lordship.
Yes.
Lordship, where it has been mentioned, an overhead line shall, with the prior approval of the appropriate government, be installed or kept installed above the ground in accordance with the provision of subsection 2. Lordship, subsection 2, the provision contained in subsection 1 shall not apply in relation to an electric line which has nominal voltage not exceeding 11 kilovolt. Lordship, not exceeding 11 kilovolt. Lordship, and Lordship, and Lordship, section 54 also violated by the electricity authority. Kindly see page, kindly see section 54, Lordship. Lordship, section 54, subsection 1, clause B, Roman I.
You are Mr. Noskar.
Lordship, Arun Noskar, Lordship.
Yes.
Where it has been mentioned, save as otherwise exempted under this act, no person other than central transmission utility or state transmission utility or licensee shall transmit or use electricity at a rate exceeding 250 watt and 100 volt in any street or in any place in which 100 or more persons are ordinarily likely to be assembled. Lordship, there also, Lordship, situated one masjid where 300 people, Muslim community assemble every day, Lordship. So I'm praying, Lordship. Lordship, after supplying this copy by the electricity authority, petitioner and other villager first time came to learn about the order of your Lordship. Lordship was pleased to pass order. Kindly see, Lordship, page number 37. It has been. Lordship, page number 38, last paragraph, in last paragraph, Lordship was pleased to observe and noted, Lordship, page number 38, Lordship.
Will not give a stamp of validity if it is in contravention of some law.
Lordship.
You really.
Lordship. And Lordship's station manager granted this permission. Kindly see page 40, Lordship. Contract demand 20,000 watt, 20 kV, Lordship. 20,000 watt means, Lordship, 20 kV.
Very.
That is here. Lordship.
Yes, yes, Mr. Mukherjee.
My lord, I have taken the instruction. Kindly see, my lord, the annexure, page 13, my lord, annexure P1, although, my lord, annexure P1, yes.
Mr. Noskar, please take your seat and ask her to take it. Yes.
Now, my lord,
Yes, sir.
this particular private respondent in the present writ petition filed a writ application before the Lordship's court that, my lord, they have in possession, they want industrial supply, but we are not providing supply. Your Lordship was kind enough, kindly see your Lordship's order, my lord, at page 37. But kindly see our submission. Learned, page 37.
Yes.
Learned Counsel appearing for the distribution licensee submits that the licensee was intimated by its said contractor that due to resistance by the local people, the connection cannot be given to the petitioner. However, upon query of the court, learned counsel for the WBSCDCL submits that no written objection has been filed by any of the said local people. It transferred that due to some unknown reason, certain people may be resisting the giving of the electricity connection to the petitioner. However, the petitioner as an occupier cannot be precluded from getting an independent electricity connection in the petitioner's name within the contemplation of Section 43 of the Electricity Act 2003. Hence, the WPA 8617 of 2023 is disposed of by directing the WBCL to give the electricity connection to the petitioners as expeditiously as possible, positively within a week from date. In the event any obstruction is raised by any quarter to the giving such connection to the petitioner, it will be open to the WBSCDCL personnel and or their
Police assistance,
Yes.
usually. Yes.
Now, my lord, however, nothing this order shall create any special right or equity in favor of the petitioner, which the petitioner does not otherwise have in law. Now, what happened after your lordship's order? Kindly see the date 18th April 2013. For the first time, my lord, kindly straightway come to page 41.
Yes.
Kindly see bottom, my lord, left hand side, date 3/5/2023. Your lordship's order is that, my lord, 18th April. 18th April, we have submitted no written objection. Now, what is the kind of written objection? Kindly see, my lord, 10 line from top. May I just read for your lordship?
Yes.
আমরা এর প্রতিবাদ করছি ব্যক্তি স্বার্থ, মানে your lordship will find, my lord, from one.
No, I found it.
Yes. আমরা এর প্রতিবাদ করছি ব্যক্তি স্বার্থের জন্য অতগুলি লোকের জীবনের ঝুঁকি উপেক্ষা করে এতগুলি বাড়ি ও মসজিদের খুব নিকট দিয়ে ইলেকট্রিক তার নিয়ে যাওয়ার প্রস্তুতি চলছে। এটা কি ঠিক হচ্ছে? মসজিদের বিভিন্ন অনুষ্ঠান হয়ে থাকে, তার জন্য আশেপাশের পাড়া থেকে বহু মানুষ জমায়েত হয়। আর তাছাড়া ভবিষ্যতে মসজিদের এক্সটেনশন হতে পারে, ইলেকট্রিক তার গেলে তাদের বাধাপ্রাপ্ত হতে পারে ইন ফিউচার। এই খুঁটিগুলি যেহেতু অনেকগুলি বাড়ির লাগোয়া, বম্বে রোডের ধারে বসবে, যে কোনো সময় গাড়ির ধাক্কায় দুর্ঘটনা ঘটতে পারে এবং বাড়িঘর জ্বলে যেতে পারে। This is the objection. Now the question, I have taken the instruction, although I am not appearing for the NHI, but the person who are raising the objection, they are in occupation of unauthorized land, which is to the government. Now, my lord, they are registering the obstruction. Now, my lord, we are proceeding in terms of your lordship's order. Now, my lord, we also could not provide the connection due to resistance and police is not cooperating. We have last, my lord, to comply your lordship's order, wrote to the superintendent of police. Now, my lord, that is yet to be done.
Mr. Mukherjee, file your opposition. Put this on record. Till then, don't give the connection. I'll pass my order.
And my lord, only one thing, my lord, Rule 26 says has not been dispensed with, the private respondent has been made party. Kindly see that. I'm just, this is my submission. Page 3, my lord, the earlier writ petition. I want to show the conduct. I am for the authority, I have no interest, but the conduct, kindly see, my lord, initially they did not file any objection. When your lordship passed the order, then first time they are filing the objection. Now, my lord, there is no urgency also, my lord, it has been paid if your lordship see the prayer. But today in the morning, they mention, my lord, for urgency. They can, my lord, subject to correction, my lord, that they can serve the copy because I have nowhere, because I have to compare your lordship's order. Because if I don't, my lord, they have already issued a contempt notice, my lord, that they have sent in my WhatsApp, in my copy, my lord, I will produce on the next day. They have already, petitioner has already sent a notice of contempt. Now we are in the middle position.
You have not sought for any 26 leave. How can I pass an order without service of copy on the private respondent?
Lordship,
He enjoys an order now.
Lordship, in the mean period, if they connect this high voltage electric line, they affect the life of the petitioner also.
Why did you wait for so long?
Lordship, the private respondent did not implement this petitioner, including any other villagers, to the previous writ petition. So petitioner and other villager was not aware about this matter, Lordship. So by suppressing this fact,
I'll pass an interim. Learned counsel for the petitioners contends that the petitioners and other villagers have raised an objection to a high voltage electricity line being given to the private respondent by the WBSCDCL. Full-stop, it is contended that the petitioners were not aware of a previous order passed by this court in favor of the private respondent on April 18, 2023. and only subsequently, comma, the same came to the knowledge of the petitioners. First up, it is argued that the line proposed to be given to the private respondent is of about 20 kV. First up, learned counsel further alleges that the WBSCDCL is giving such connection in gross violation of the provisions of sections 54 and 68 of the Electricity Act 2003. First up, next para, learned counsel appearing for the WBSCDCL submits that in view of the order dated April 18, 2023, comma, the WBSCDCL is merely complying with such order by seeking to give connection to the private respondent. First up, in that regard, comma, as directed by this court, comma, the WBSCDCL also sought for police assistance, but could not obtain the same in the meantime. First up, next para.
Another submission kindly record, my lord, that one we are giving the connection in the place of the private respondent place, private respondent residence, and my lord, the petitioners who are raising the objection, they are occupying in the land which is the government.
Next para, learned counsel for the WBSCDCL contends that the petitioners are illegal encroachers of government property and that the electricity connection being given is intended to be so given at the premises of the private respondent. First up, next para. Upon hearing learned counsel for the parties, comma, it transpires that as yet no copy of the writ petition has been served on the private respondent, comma, although a notice has been given to the learned advocate appearing for the WBSCDCL. Full stop, next para. A bare perusal of sections 54 and 68 of the 2003 Act indicate that no person other than the central transmission utility or state transmission utility or a licensee shall transmit or use electricity at a rate exceeding 250 watts and 100 volts in any place in which 100 or more persons are ordinarily likely to be assembled. Full stop, next para. It is further provided in section 68 that with regard to overhead lines, comma, prior approval of the appropriate government is required to be taken for such installation. Full stop, next para. It has been alleged that in the present case, comma, no such permission has been taken and that the area in question is a heavily populated area, including a masjid, comma, where several people congregate regularly. Full stop, next para. The petitioners have made out a strong prima facie case as regards the electricity connection sought to be given being in violation of section 54, comma, if not section 68 as well, comma, of the 2003 Act. Full stop, irrespective of the petitioner's occupation of the area being legal or unlawful, comma, the same does not provide an exception within the contemplation of section 54 of the 2003 Act. Full stop, since it has been alleged by the petitioners that several people, comma, more than 100 regularly congregate in the area, comma, it is prima facie doubtful as to whether the order dated April 18, 2023 gives a charter on the WBSCDCL to violate the same. Full stop, next para. That apart, comma, the present petitioners were not impleaded in the previous writ application bearing WPA 8617 of 2023, where the order dated April 18, 2023 was passed, and none of the parties therein took the canvassed the issue as regards probable violation of section 54 if the connection is given to the petitioners. If the connection is given to the present private respondents, bracket A, writ petitioners therein, bracket closed. Full stop, That apart, comma, in the order dated April 14, 2023, comma, it was clearly mentioned, clearly observed that nothing in the order shall create any special right or equity in favor of the petitioner therein, bracketed present private respondent, bracket closed, which the said petitioner, bracketed private respondent, does not otherwise have in law. Full stop. It was also observed that furthermore, comma, nothing in the order shall give the stamp of validity in the event the industrial connection is being taken by the petitioner dehors or in contravention of any existing law. Full stop. Since a prima facie case of contravention of sections 54 and 68 have been made out by the petitioners, comma, leave is granted on the oral prayer of the petitioner to move the writ petition within the contemplation of clause 26, that is clause 26.
26 capital A.
26 capital A. Thank you. Clause 26 capital A of the writ rules of this code. Full stop. Next para. The WBACDC, the respondent numbers 2 to 4 shall remain restrained from giving electricity connection to the private respondent numbers 8 at the proposed site, comma, as per the provisional quotation annexed at page 40 of the present writ petition, comma, till June 15, 2023 or until further order, comma, whichever is earlier. Full stop. The petitioner shall serve copies of the writ petition on the respondents who are unrepresented in court today immediately and shall file an affidavit of service to that effect on the next date of hearing. Full stop. The service on respondent numbers 2 to 4, I am dispensing, Mr.
Only thing in the morning, your lordship directed me to appear with my junior.
I'll regularize. কি বললাম? Just last it. Numbers 2 to 4 is dispensed with in view of appearance through learned counsel. Full stop. Next para. Since the service was effected on Mr. Devjit Mukherjee, comma, an advocate practicing in this court, on behalf of respondent numbers 2 to 4, comma, let such appearance of Mr. Mukherjee be regularized by the said respondents in connection with the present writ petition. Full stop. The matter shall be listed next for hearing on June, in the monthly combined list of cases for June 2023.
Lordship, there will be, instead of 100, 300 people will be.
Use the microphone.
Instead of 100, 300 people will be there. I have
More than 100, I've said. 100 is the statutory bar. That's why I've stated more than 100. We have to be vague on that unless they use their affidavits. আচ্ছা affidavits, আচ্ছা মেঘনাদা একটা কাজ করুন, একটু বাড়িয়ে দিন ওটা। আর যেটা ইন্টারিম অর্ডার বললাম সেটা till June 30, 2023 or until further order, June 15 বলেছি, 30 or until further order, whichever is earlier. Or the matter shall next be listed on June 19, 2023 for hearing. Affidavits, if any, shall be exchanged in the meantime. Serve them immediately, the other respondents.
Item number 23, assigned matter.
Yes.
It's my petition, my lord. Before my lord takes up the writ petition,
Yes.
lordship will kindly take, there is a connected application pending, my lord, which is, my lord, my amendment application. My lord, this amendment application, my lord, is, my lord, has been
only one thing, my lord, before my learned friend proceeds. My lord, before the amendment is made, my lord, the cost title needs to be
I
amended.
have amended that, my lord. Pursuant to your lordship's last direction, I have amended that.
because Andhra Bank, my lord, is no longer in existence. My lord, that
I
has to
have-
be substituted by Union Bank.
লিভ দিয়েছিল অর্ডারটা দেয়নি তোমাকে আমার লিভ নিয়ে চেঞ্জ করা আছে হ্যাঁ। সেটা কজ লিস্টটা চেঞ্জ হয়
অ্যাপ্লিকেশনটা কোথায়? অ্যাপ্লিকেশনটা অ্যাপিয়ার করছে আজকে লিস্টে?
Yes, yes, my lord. It's appearing.
ওনাকে অ্যাপ্লিকেশনটা বার করে দিন। আপনি তো বার করবেন, ওনাকে কেন ছাড়ছেন? আপনি তো এর বেশিও।
196. Pursuant to your lordship's last direction, I have made that changes, my lord.
Let me find out the application first.
My lord.
বাকি ফাইলটাও দিন। Can 1961? No. 1961?
196.
Very good. Yes, what is the matter?
Well, before I go into this application.
Amendment of the review.
My lord?
Amendment of the review application.
No. Amendment of the writ petition, my lord. In
Review
view
was
of-
allowed.
Yeah, review was allowed. May I, my lord, say?
Very
My lord,
good.
I was, my lord, pursuant to my lord tender published in 2010, my lord, I purchased a property from my lord, the then.
In the
Andhra Bank.
application, it has not been corrected. The cost title, Andhra Bank is still there.
It's been corrected in the writ petition, I think. My lord, it's a connected application, so my lord, in
Not automatically.
appellate side,
This application has not yet been allowed.
I will ask my on record, my lord, to have it corrected. Lordship will kindly hear it out in that even.
Very well. During the course of the day, can you do
I
it?
will,
Very
definitely.
good. Yes. Moving on. Mr.
Uh,
Bandyopadhyay and Mr. Rai, please take your seats, all of you. Yes.
My lord, pursuant to my lord, tender, my lord, published in 2010, my lord, I purchased a property from the then Andhra Bank by way of my lord bank auction. My lord, I paid.
By way of
Bank auction, my lord.
auction.
Auction. I mean, I paid somewhere around my lord, 28 lakhs, my lord, for that property. Now, subsequent to that, my lord, I was seeking possession, my lord, of that property. Now, somehow or the other, my lord, the respondent bank, my lord, was not giving me the possession, my lord, delaying with it. And I kept on writing, my lord, requesting the bank, my lord, to give me the possession. At this juncture, what happened, my lord? An FIR was lodged against me by, my lord, the respondent number 3, saying, my lord, that bank has sold off a property, my lord, that belonged to the respondent number 3, the private respondent. I mean, that is the same property which, my lord, I purchased by way of bank, the auction, my lord. Subsequently, after receiving, my lord, that FIR, my lord, my lord, caused some searches to be done.
They were
And
not the debtor.
They were not data, my lord. They were
So
not.
they did
data.
not take this point during the e-auction, before the e-auction.
No, my lord. No, I
Yes.
was a straight purchaser. Now, after that, my lord, I caused some searches and I found that, my lord, there is a title suit pending, my lord, before, my lord, the Jalpaiguri court, filed in 2006. Now, this notice was issued in 2010. The suit is of 2006, where, my lord, bank is a party. And, my lord, there is a subsisting order of injunction as against that property.
Regarding transfer.
It has been transferred in 2010. Now, my lord, I sought, my lord, the bank stand, my lord, altogether was that the properties are not same. Now, I then came up with this writ petition saying that either, my lord, give me possession or refund me the money that I have paid. Now, my lord, what transpired after that is the bank, my lord, preferred an opposition saying that the properties are not same. The respondent, the private respondent also, my lord, came up and said that the properties are not same.
Are not same.
Not same. So, my lord, I said that, my lord, then give me possession. What happened after that is, my lord, very interesting. Then, my lord, came that review application filed, my lord, by the respondent number 3, the order, my lord, which is there annexed at page, my lord, 57. There, my lord, the it's a review petitioner, my lord, is the respondent number 3 here. Now, in that review application, my lord, what transpired is that the private respondent contended that no, we made a mistake, my lord, while drafting the plaint. The DAG numbers and all were not correctly incorporated in the plaint. It is the same property, my lord, which is there. So, my lord, the plaint, I have amended the plaint there before the Jalpaiguri court. So, my lord, the order that was passed by this honorable court directing the bank to give me possession, which is there, my lord, prior to that, should be recalled, and the petition should be restored. Now, my lord, that order was allowed. I mean, that review application was allowed. And, my lord, what happened? The previous order was recalled, and, my lord, it was back to square one. So, well, this facts post my filing of the writ application has not been incorporated and has not been dealt by either the bank, my lord. But what stands today, my lord, is that the private respondent has taken a stand. They have incorporated, they've amended the plaint there. They've taken a stand that the property belongs to them. Bank, in spite of having knowledge of the fact that that they were a party to the proceeding, had issued the tender notice, and had, my lord, they're enjoying the, my lord, that 28 lakh rupees since, my lord, 2010. So I've come up with this review application, my lord, because to incorporate the order of the, my lord, the reviewing court, my lord, because it's necessary, because now, my lord, it's settled that the property, the bank is not in a position to give me the property because it's part of litigation, litigated property, it's pending in the suit. In spite of knowledge, they have sold it to me. So I was seeking, my lord, to seek refund, my lord, to press one prayer in the writ application. It was necessary, my lord, that I bring these facts on records. But that is, my lord, the amendment
Was the
application.
petition originally for the same prayer?
There were twofold prayers, my lord. Either give me, my lord, possession.
Money or person?
Yes, either of the two, my lord. If you can give
By
me
way of the amendment, you are now insisting on the
refund, my lord,
refund
because
of money.
it's possible for the bank to give me the land, because it's stand of the respondent number 3 that the land belongs to them. They have amended the suit. I am not a party in the suit. I don't know how long that suit will run.
You are the beneficiary of a violation of an injunction order without knowing about this.
Without knowing anything. 2006 suit, 2010 tender notice. I have purchased in 2010. The writ petition filed in, my lord, 2011. Since then, my lord, I'm my 28 lakh rupees is my lying with the bank. My lord, this is the present situation. Very short of facts. If, my lord, the application is allowed, my lord, these facts are maybe incorporated in the writ petition. And, my lord, if, my lord, the private respondents want to, my lord, deal with that, they can. Otherwise,
I am allowing that right now.
I have no objection. Only thing, one amendment, my lord, I do not know why it has been done. And it comes to
I'll hear the bank also on the amendment. Yes.
page 105, 1. So in fact, that order of amendment of the learned court was challenged by the bank before, my lord, this honorable court by way of revisions that has also been discussed.
Mr. Bandyopadhyay, satisfy me that order of amendment that did that specify whether it related back to the date of the filing of the suit?
Yes, yes. My lord, only the, my lord, in
Show me
fact,
that order once. Do you have a copy? No.
so that has been now assailed before the revision court and the honorable justice passed to have.
No, even if it is assailed and it has been affirmed, it remains the same. The trial court's order has not been varied then.
I don't know whether it has been annexed or not.
Unless it was still from the date of the amendment, if nothing is specified, we can probably presume that it was from the date of relates back to the date. But otherwise, I mean, the injunction whether
That was the finding of the review court also. The kindly see the judgment, it starts from page 57. That issue is no longer, my lord, because it was already dealt with, but no appeal was preferred either by the bank or the.
I'm not on the question of amendment, Mr. Bandyopadhyay. On the effect of the amendment. Amendment has been allowed, that is beyond.
One thing, my lord, can you take page 105? My lord, that is the, my lord,
No, where has been discussed in Justice Chatterjee's order. Let us see that.
the amendment.
By mistake, wrong schedule.
Lordship will kindly come, that order starts at page 57. Lordship will kindly come to page 60. That's, my lord, the submission on behalf of the private respondent.
No, that is the wrong schedule was mentioned.
Yes,
and all.
my lord, yes.
That is
supported by deed also.
Let's see the lastly what was passed.
Lordship will kindly come to page 74. And the amendment, my lord, took place after, my lord, the writ petition was disposed of. Directing the bank to, my lord, give me possession.
But that order was reviewed.
That order was reviewed.
So after that, the writ petition was heard. This is that writ petition.
It's that writ petition. my lord.
That is revived, the petition has been revived.
That is the present writ petition.
That is the present writ petition, my lord.
It was not hard.
It was not after that.
My lord, if you also kindly
No, I'm
take-
not that Mr. Shengupta that is there, my lord, in the order.
What was the effect? No, obviously, we're not.
Can take the original petition, my lord, the prayer was at page.
So amendment, let me allow first, subject to hearing the bank. Then Mr. Bandyopadhyay will take up on the review the writ petition itself.
Lordship will kindly do that.
I don't have any problem.
What is your stand on the amendment?
Lord, so far as the
Kindly come to page 105. They are taking that proposed amendment. Why they have deleted these 4 lines, I don't know. Because that runs contrary to their case.
So it doesn't run contrary, my lord. The bank cannot give me the possession today, standing today.
What they are saying, petition no more interested to purchase the said property as they have been deliberately misled and decide. That was the original statement.
Because the bank cannot give possession now. The Lord clarified it.
That was the original statement in the writ petition. Now they want to delete it.
It was the other way around in the dispute. Oh, acha, no, acha, very well. It's the other way around.
And what was the prayer, my lord? They asked for the main prayer was for refund.
Now they are interested to purchase also.
Now how it is you can.
So that we need not go into that now.
Only to that
But in the writ petition also, my lord, the grievance was against the bank only, my lord.
Let me hear Mr. Rai on behalf of the bank. Then I'll come back to you for a reply on this. The point taken by Mr. Bandhu.
But so far as my lord, we are only, my lord, on the point of amendment today, my lord, not
Yes,
on the writ
only
petition.
not
Yes.
today. Now,
Now.
after that we'll decide what we'll do.
No, my lord. For the writ petition, if the amendment is allowed, my lord, I'll, my lord, be seeking time to file an opposition to the amended.
Very
writ
well, what is
petition.
your contention
Yes,
on
my
that?
lord. So far as the amendment is concerned, my lord, the point, my lord, that the property which has been sold is owned by somebody else and not, my lord, is owned by somebody else, and it has not, bank had no title over it because the mortgage was not proper. My lord, this fact has been, my lord, contested by the bank before the learned court below. It is being contested, my lord, on
In the
my lord,
suit.
in the suit. My lord, we say, my lord, that the plaintiff over there does not have title.
Not that Mr. Rai, in this, despite an injunction being there, if you have transferred,
Yes,
that
my
was
lord,
in violation of the injunction. How could you
yes,
do that?
that, my lord, we will have to deal, my lord, we will deal with it. My lord, if
So then,
if
where
there
is the
was-
scope of your selling the property? I mean, where is the scope of giving possession now? Why shouldn't you refund? I mean, although there is a sale certificate, everything is there, must be there, auction sale, but you should pay up.
My lord, that will come, my lord, only if, my lord, he crosses the hurdle of caveat emptor. My lord, because it was an auction sale. My lord, I will disclose, my lord, whatever is known to me as an encumbrance in respect of the property. My lord, if the plaint is amended subsequent to the sale, my lord, I do not know what the property is. My lord, if in the plaint, my lord, despite knowing that, my lord, I have title to the property which has boundaries X, Y, Z, my lord, I mention A, B, C. My lord, I will not.
Very well, then I'll allow the amendment and look
So
at
it
it.
was a
Because these are subsequent developments we will have to
Yes,
bring on.
yes, yes. That is why, my lord, I said on the
2006 suit, my lord, tender notice in 10.
What
lakh.
about this
Had
Mr.
6 suit-
Bandyopadhyay's point, 105?
My lord,
Our-
2006.
our- it was a-
2006 suit, my lord, in respect of a land which was described differently. My lord, that is, my lord, therefore, my lord, it's not that the bank has come, my lord, with some sort of a malafide stand.
In fact, 2006.
Now, 105, what is your answer to that?
Well, all through, my lord, my grievance was as
No,
against.
you are
the
now
bank, my lord.
deleting this line. Mr. Bandyopadhyay is right on that. The petitioners, you originally said you are not interested to purchase the said property. That I can appreciate. Yes, you wanted to confine yourself to refund. But now why
think, my
delete
lord,
that? Now you are
I
interested
will,
to
my lord,
purchase.
confine myself to, my lord, refund only. In that event, this portion I will, my lord, not incorporate.
No. Then if you stand by this portion, I'll allow it in any event. It's an amendment application. But then you are now interested also to purchase.
I'm,
I'll allow the amendment also.
Actually changes the nature and character. They will be hit by.
let Mr. Bandyopadhyay.
Oh, you say they had relinquished the right, but now they're trying to assert that right.
It's a change of case.
Acha.
I'm standing to the my lord, I will, my lord, I'm interested in refund only, my lord. So in that event, lordship make.
That portion cannot be allowed, my lord. Only that portion. I'm not objecting to the other portion.
But one more, my lord, just to bring it to your lordship's kind notice, my lord. The order of review, my lord, was passed on 21st of February 2017. My lord, the amendment application, my lord, was made in 2020. My lord, 3 years after that. His cause
Before
of
the
action, my
writ
lord.
petition was finally heard out.
Yes, but my lord, he came to know about it 2017.
But this is not a suit, Mr.
No, my lord,
But
in
the-
that event also, my lord, I'm with him.
The rigors of suit, my lord, in some cases apply to
with you, my
writ
lord.
petitions
February-
also. My lord, lordship is.
I'm
Principles apply.
in that
I'll apply the principles.
In that event, I'm also within. The order is of 21st February 2017. I formed on 14th February 2020. 7 days prior before closing of 3 years.
7 days?
Before my lord, closing of 3 years. 21st September 17 and 14th February 20.
They can't file amendment applications, my lord. Well, if you did the suit, my lord, now after the amendment.
Can't
if
oppose
the trial
Mr.
has not begun.
I'm not being able to oppose Mr. Rai vehemently today. He is my arbitrator.
submit, my lord, let that portion remain. My lord, I am.
No, but Mr. Bandyopadhyay, that relief was initially sought in the writ petition.
Yes, my lord.
Both
that was-
reliefs were sought.
Both
So
reliefs
writ
were sought.
petition nature and character does not change. Relief is not time bound now.
Relief was not time barred. What I say, my lord, their case was something different. They did not want to.
No, there was a discrepancy between the body of the writ petition and the relief. Now they want to delete that. Let them delete it.
Relief, primary relief is refund. My lord, kindly come to.
Not only refund, they are also seeking alternatively possession.
They asked for, my lord, I have to check, my lord, probably they didn't ask for alternative.
Let us see that.
My lord, kindly take my page 110. It starts from 109.
Let us see the reliefs.
So, my lord, page
In the
29.
writ petition, yes, 20.
28, my lord, it starts from 28.
27 actually.
My brief is 28. But you will read or read in the nature of mandamus commanding the respondent authorities under each of them to act in accordance with law, refund the said total sum of rupees 31,67,000 as stated in paragraph 21. Then there is the writ of prohibition. Then the writ of certiorari. Where is the prayer? Now, if that amendment goes, my lord, incorporate.
Even then, nothing hinges on that, Mr. Bandyopadhyay. If that your submission is correct, even then the relief has not been sought. By way of the amendment, they're just deleting that. So that the same logic applies, what you are saying.
As you lord. But I'm just pointing out because.
No, you're right. You're right. That is a right thing you have pointed out. Learned Counsel, I'm just allowing the amendment application, then I'll Learned Counsel appearing for the writ petitioner submits in support of the amendment application bearing CAN 1961 of 2020 that certain subsequent developments which are germane to the adjudication of the writ petition have been sought to be incorporated in the writ petition by way of the amendment. For next para, certain developments which took place after the filing of the writ petition necessitated the writ petition to be seen in the context of such facts. A perusal of the amendment application indicates that the same pertains primarily to subsequent developments and ought to be incorporated in the writ petition. Next para, Learned Counsel appearing for Mr. Bandyopadhyay, you are for which respondents? Three. Appearing for respondent number 3 objects to a particular portion of the amendment, that is at internal page 24 of the internal page 24 of the suggested amended writ petition within bracket running page 105 of the amendment application bracket closed, where the petitioners seek to delete the averment that they are no more interested to purchase the said property. It is submitted that the deletion of the said averments virtually indicates that the petitioners are now agreeable and interested also to purchase the said property, which relief cannot be taken after such long pendency of the writ petition. Next para, Learned Counsel appearing for the bank submits that the petitioners are not entitled to get relief with regard to refund for reasons as pointed out by Learned Counsel for the bank, including that the bank was not at fault in the property being sold to the petitioners, since the bank did not have any knowledge whether there was the suit was filed after the order.
The suit was filed not prior to it, but
did not have any prior knowledge.
The schedule of the suit was not that which was the
Right. Prior knowledge as the schedule of the suit was amended subsequently. Next para. Be that as it, arekta line add korin. Learned counsel for the bank also contends that the facts sought to be incorporated came to the knowledge of the petitioners even as per the amendment application, comma, in the year 2017, comma, whereas the amendment application has been filed only in 2020. Full stop. In the absence of any explanation for such delay, comma, it is argued, comma, the amendment ought not to be allowed. Full stop. Next para. A prima facie perusal of the amendment application clearly indicates that the facts sought to be incorporated are subsequent events, and there is no bar as such in permitting such amendment. Full stop. Insofar as the delay of 3 years is concerned, comma, since the writ petition has itself not been heard out as yet, comma, nothing hinges on the said delay insofar as the interests of the parties and or the parties being taken by surprise are concerned. Full stop. Next para. Inasmuch as the argument of the respondent number 3 is concerned, comma, mere deletion of the statement in the original writ petition where the petitioners had said that they are no more interested to purchase the property, comma, cannot have any bearing on the adjudication of the writ petition. Full stop. Moreover, comma, by way of the amendment, comma, the petitioner has not asked for the incorporation of a new relief apart from the refund of the amount primarily, comma, to hold that the present amendment application seeks to confer certain extra rights on the petitioners which they did not have as per the original writ petition. Full stop. Be that as it may, comma, since it is well settled that courts are liberal in allowing amendment applications, comma, particularly with regard to subsequent developments, comma, there cannot be any occasion for not permitting the petitioners to have their writ petition amended as prayed for. Full stop. Accordingly, Can 1961 of 2020 is allowed, comma, thereby
Amendments, my lord, are at page 99 to, my lord, 101, my lord, of my application, and my lord, 105, my lord.
99 to
99 to 101, 99, 100, 101, and my lord, page 105. That are, my lord, my
thereby incorporating the amendments as indicated by the red underscoring in running pages 99, 100 and 105.
105 is deletion.
100, 99, 100, 100 and 101.
Incorporation stroke deletion.
Yes.
As এই সেন্টেন্স একবার পড়ো, আমি বলেছি। Yes, amendments as indicated.
Underscored.
Incorporating stroke, no, the amendments will be incorporated. Amendments, underscore for that.
105 মিনিট।
আচ্ছা, পেজ যেটা বললাম, পেজেস গুলো, পেজ 99 and 100.
19 and 100 and 101.
And 99, 100 and 101, and treating the sentence scored through at page 105 of the amendment application to stand deleted from the original writ petition. Full stop. Next para. Let the said amendments be treated to be a part of the original writ petition. Full stop. You will file an amended writ petition. Because under the deletion is all right.
Incorporating, my lord, will be.
Can you incorporate 17? It's a longish.
It will not be possible, my lord. It will
Not possible.
I'll-
Full stop. The writ petitioners shall file an amended writ petition accordingly in terms of the above order before closing of court within May 19, 2023, and serve copies thereof on the learned advocates appearing for the respondents. Full stop. The matter shall be, the writ petition itself shall be listed for hearing on it. It crossed the motion stage.
My lord, motion
Yes, my lord.
stage. But now, my
Affidavits
lord,
have
after
been
these
exchanged.
amendments, my lord, we get an opportunity, my lord, to file an opposition.
So did you file any opposition in the first place?
Yes, yes, my lord.
In the opposition, we filed.
Opposition reply is over, my lord.
Oh,
I have a copy of the opposition filed by the respondent number 3 as well as, my lord,
first,
the,
acha,
yes, my lord, all the respondents have
returnable on
record.
বলেছি কিছু returnable on June 26, 2023, full stop. Supplementary affidavits in opposition with regard to the amended portion of the writ petition, comma, if any, shall be filed by the respondents by June 16, 2023. Full stop. Reply, if any, shall be filed by June 23, 2023. Matter is returnable on June 26th.
Deletion of last line, my lord, in 105.
For
is-
hearing, for hearing.
Lord, the
Deletion?
deletion of the last line in 105 is interesting, my lord. But it says the petitioners have
That is the
lost
most
their,
interesting thing I have, taken up after the recess.
my lord, it says the petitioners have lost their faith, trust and confidence in the respondent, my lord, that has been deleted. my lord. Their faith, we have regained faith, my lord.
After you came into the picture, probably, both of you, all of you.
Whatever Mr. Rai is saying, I could not oppose today. He is my arbitrator and I am the, my lord, claimant before him today.
Today,
Today, my lord, by your lordship's order, he is, my lord, the,
I'm also a party to it, so I should not comment. Mr. Bandhavadar, so your prayer is answered in any event.
The only thing, my lord, this is of 2011, and although, my lord, this amendment took place in 2016, my lord, but they were aware, that is why.
2020.
They were aware, that is why in 2011, they, my lord, filed this writ application for not claiming refund on. And in fact, my lord, on the basis of a deed, my lord.
They said they were fed up with the
No,
bank.
in fact, what happened, my lord, on the basis of a deed of purchase, my lord, the suit was filed. The deed of purchase, the schedule is mentioned in the deed. But it was wrongly mentioned in the plain. Only that corrections were.
all said and done, I am out of pocket by 28 lakhs with a paper sale certificate. Nothing else.
Bank was not
What
aware. Bank was very much aware. Knowing fully well, they sold it out.
We'll come back, my lord.
Lord, if knowing fully well, my lord, plaintiff is drafted, my lord, we can, my lord, plead unawareness.
And my lord, I'm stuck between, my lord, two, my lord,
Resolve it outside.
Grateful. my lord.
Thank you.
Item number 24.
Never. Item number?
24. Item number 24.
দেখি দিন।
My lord, and for the petitioner, my lord, as per earlier order, my lord, advocate on record contacted other respondent advocate, Miss Joyita Sinha, who is not in.
Take the microphone, take the microphone.
Who is now out of station, and thereafter, as per notice served upon the her clerk, but clerk refused to receive the notice. My lord, I have the notice in this, and she is sitting in Bal Library Club, first floor. But the Joyita Sinha, the appearing advocate.
The clerk has to affirm an affidavit to that effect. I'll direct service on the respondent. You have to affirm an affidavit saying that it was refused. Otherwise, I cannot pass the direction.
Yes, my lord.
Since
Otherwise,
advocates
my
were
lord, she is coming after, kindly keep it on after vacation.
Very well.
Then I further
on the prayer of learned counsel for the petitioner, comma, since service could not be effected on grounds beyond the control of the petitioner in the meantime, comma, the matter is adjourned and shall next be listed in the monthly list of June 2023. Reopening.
She is now out of station, and after that. Yes.
Item number 25.
There is that assigned
Number
matter.
25.
My lord, I had a.
Can we release assigned matters?
Twice
My lord-
released before it came to your lordship.
Oh, acha, twice released.
My lord, I am not insisting your lordship to take up the matter today because Mr. Chaudhary is not here.
Becoming.
So, my lord, I have a small proposition.
Yes.
Subject to what my learned friends consider, because there are two parties now. My lord has passed an interim order after hearing us in detail. My lord said that the property provisional attachment order with respect to the particular property of the petitioner should be stayed. And thereafter, your lordship directed them not to alienate it to any party during pendency of the writ petition. Now, in the meantime, my lord is aware that provisional attachment order was taken up in adjudication. It was going on when this matter was going on. Final order has been passed confirming the attachment of all properties, including that property of the petition. Now, all the parties over there has preferred appeal before the tribunal against that final order. Now, tribunal is now functioning, regularly functioning, matters are being taken up. Now, I had a proposition that if your lordship wants, your lordship can dispose of the writ petition, keeping that interim order that the attachment order with respect to the property of the petitioner will remain stayed, subject to outcome of the appeal. If they are agreeable to that, it can be done. Because
Mr. Chakravarti, but if I dispose of the writ petition, subject to outcome of the appeal, whatever happens, it can go either way. So if suppose they win in the appeal,
yes,
then I mean,
then entire attachment goes.
yes, and if they lose in the appeal, then the final attachment.
They will come in appeal. They will come in appeal before this High Court only.
Oh yes, right.
Against tribunal order, the
Yes,
appeal.
take instructions on that.
That we'll have to come back.
Take instruction on that because that's a very reasonable proposition. Apparently, unless there is something else you have to submit.
Something hidden in it. We will take it.
I have
No. He has not hid anything, but for you it may be something. I
Yes,
mean,
my lord, actually, the only thing is that our main case was that they are not proceeding against the real proceeds of crime. So, my lord, if those
that is something
proceedings go
different.
on- No, that is what my lord had.
No, that is not the scope of I subject correction. That is
My
not
lord, let us take instructions and come
no,
back.
take instruction definitely.
because that order.
Should I keep it? Tell me after instruction. If, I'll record the.
Because my lord may recollect that Supreme Court order where the Honorable Supreme Court observed that even if provisional attachment is quashed, my lord, what happened?
Justice Khanwilkar.
Yes. Now, my lord, what happened? There is little development. That order has been relied upon by the Honorable Chief Justice in the Division Bench of our Honorable High Court and held the same, that even if the provisional attachment is quashed, final order can be passed.
Relying on that.
Relying on that. So that will also be there.
No further development in Supreme Court regarding that order. Offer has been given.
Yes.
So whether it is a concluded contract, that will be decided by you and your clients.
No. I'll find out.
Please find final order of attachment has been passed in the meantime. Your learned friend was suggesting for the ED that if the interim order which has been passed can be continued and the petition disposed of with that order, this will be subject to the outcome of the appeal, challenging the final final order of attachment. If you win the final order of attachment, the entire thing goes, you win the entire thing. And if you lose, that you will have to consider.
I prefer proceed before your lordship. Clearest case possible. Whole thing will go.
But ultimately, the provisional attachment only will go, my lord. That is what I was suggesting.
If it goes, you can't have a final order of attachment.
No, final order of attachment can be there, my lord. That is what I was suggesting. The final order has already been passed. That is not assailed.
When it is passed, does it survive if this is set aside? Unless you challenge this also.
Cannot be.
Because of the Supreme Court, Justice Khanwilkar's
No,
order
no,
and the Honorable Division Bench order.
That has been.
What is
dealt
that
with by your
order?
lordship.
Just remind me that.
No.
Why can't the provisional order of attachment that detaches the provisional order from the final order? Justice Khanwilkar's judgment?
Yes.
I have just please just remind me of that portion.
That
The
judgment is
জজসাহেব ডিল করে দিয়েছেন that পয়েন্টটাকে। Like that is being used all over.
Infrastructure Development Corporation Limited.
that finding, what was that finding? It was exhaustive, need not place the
No,
entire
I'm just reading that part.
the relevant part.
What
Yes,
is quoted by our Honorable Division.
absolutely. That will be better.
In other words, the fact that the petitioner has succeeded in pursuing the High Court to quash the provisional attachment order passed by the appropriate authority under
yes,
Section
yes, right.
5(1) will in no way
Right.
impact the adjudication process initiated before the adjudicating authority, which must proceed on its own merits in accordance with law.
No, proceeding is different.
Well, proceeding will end in the order only.
But will it not be subject to the fate of the provision? But the logic in that judgment, I mean, presupposes that the final order will also be
I
implemented.
go with your lordship, but I have to.
No, you are right. You are right. The logic of that judgment probably
my lord will
is
tell you-
against what we are saying.
And my lord will tell you, see paragraph 25 of this statement, this is not reported. I am giving a copy to my learned friend also for his consideration also. This is passed by our division bench. No. Just consider them. Paragraph 24 and 25 on this issue.
Yes, para 25 is very, very specific. That is our division bench.
So probably fighting on this provisional attachment now will not lead us anywhere.
Your lordship's, my lord, reading of Kaushalya is, the said judgment does not lay down a blanket proposition of law that in no case the adjudication under section 8 would not be nullified due to invalidation of the order of provisional attachment under section
There is
5.
scope of argument, Mr. Chaudhuri, regarding this para 25 of chiefs of the division benches.
That I have
Observe.
not read. I'll just quickly see.
This is subsequent to my lord's interim order also.
In a different matter, maybe.
Yes.
But the proposition, I mean, unless this is also subjected to that rider, I mean.
No, in that case, yes, it will not. In that case, of course, it will not. But in my case, things are different.
No.
If you are confident, Mr. Chaudhary, I can hear you on merits also.
Yes, yes.
Or would you like to take instruction on this?
No, no, my lord, I am absolutely confident.
Okay.
Because I'll tell you, lordship, why.
Hmm.
This is a rare case where my client, my lord, is not perpetrator of the crime. Normally, while challenging PMLA action, your client is the perpetrator of the crime. And he is, my lord, the beneficiary of, my lord, proceeds of crime. So, my lord, the equitably, my lord, the odds are against the petitioner. But in this case, my client, my lord, is by misfortune, is the brother of my learned friend. My learned friend is the person who has borrowed money from Allahabad Bank.
But what happens, Mr. Chaudhary, if you win here, but the final order of attachment is affirmed?
They will not affirm it.
It has been affirmed.
They will not affirm it.
It has been, I mean, it has been passed, but attachment
not-
order is there.
I am quite confident.
Will not affirm.
Kaushalya is
The appellate authority
misread.
will not affirm.
Then it goes in his favor.
Mr. Chaudhary,
It's a
take over.
cat and mouse game, my lord.
Pardon?
It's a cat and mouse game. Caesar, Caesar's wife, Caesar's mistress.
Caesar as in ACIZURE.
Yes.
This PMLA proceeding is that Caesar's wife.
Yes.
Basically.
Absolutely.
An adjudicating authority, then appellate authority, all my lord together. Only place of protection is court.
No, no.
Only place.
No, I will not stand by this because when I used to stand for the clients prior to 1 or 2
I have
years,
appeared in.
I appeared in
I have-
tribunal in lots of matters and we won lots of matters in tribunal.
Maybe, my lord, my learned
Not-
friends, my lord, powers of persuasion are much more than mine.
No,
I have
not at
appeared
all.
in 2 matters. Both matters, you know, one, Mr. Abratosh Majumdar was my senior. Both matters, I found that it was a futile exercise. You know, we
But
will,
Justice Khanvilkar's judgment, it's very difficult. I mean, go against that.
doesn't matter. That I don't want to go into it. What happens post your lordship's judgment, my lord, we will tackle. But I am only on a cause of action that order of provisional attachment could not have been passed. If I succeed there, that's it. Then, my lord, if they proceed, I will challenge that in another writ petition and try and get over Kanhaiya Lal. But point
So
is,
then we'll have to hear him. If they don't accept, then I'll hear you, Mr. Chaudhary.
No.
Mr. Chaudhary, you can keep this with you.
I have given a copy.
Mr. Chakraborty, I'm sorry.
yes, yes, I have a copy now.
No, I will be relying on
you will
this.
be relying.
I will be relying on
Right,
this.
right.
You know, 3 o'clock on a Friday or my lord, after vacation?
My Fridays are all the same.
Very bad.
Whatever you wish.
Vacation করবো?
আমার কোনোটাই আপত্তি
Let's,
নেই।
my lord,
Because
তোমার stay
if I
আছে?
don't hear your matter, the alternative is I'll have to go and dictate my CAV judgments. There are several thanks to you people.
Yes,
That is complicated unnecessarily. Very simple matters. So that's why I'll have to sit with those judgments now and to go through the.
I once got a
You are a major participant in that, not Mr. Chakraborty. You are a major participant in that.
and I know I'm losing.
No, depending on the matter. I mean,
That's all.
and as I said, the weather and the other aspects of the matter,
Friday
which are
afternoon.
most relevant. Friday afternoon is one of the factors, definitely.
Lordship,
And I'll have to work in that afternoon.
delivers judgments on Friday afternoons.
No, I don't deliver judgments.
No, I'm sorry. Wait, prepare. Dictate.
Yes. Delivery process is very painful.
Let Saturday, Sunday.
Nothing less than labor pain.
Let Saturday, Sundays, your lordship have whole days now. No clients to come and disturb.
No, Mr. Chaudhary, there are other engagements also, court engagements. I mean, zonal things and administrative certain things are there sometimes. Those are there.
The only, my lord, learned judge I have seen from close quarters was Justice S.B. Sinha, because both his sons were friends of mine.
He was an exception.
He, as in, I have no
He had a
interaction
phenomenal
with him.
memory and
No interaction with him. He used to look at me, I used to look at him. And that was all. We used to tiptoe outside his chamber and go and play cricket outside. But I have seen Saturdays, Sundays, whole days, he would sit amongst his papers and books. He would get up.
He was exceptional.
And whole days.
Exceptional. His entire life was revolving around those things.
Law.
I mean, academics, law, these things, which my life is definitely not.
Yes, it's not worth it.
No, not for me at least. Particularly in Friday evenings when I have to sit with your matters.
So Friday evenings, it should not detail.
Very well, I'll take it up.
After vacation, any day.
Yes, Mr. Chakraborty, what do you say to that?
I have no problem because he is enjoying stay.
He's enjoying. Very well.
But only request that my lord will kindly keep it after 12th. Because on the first week after vacation, so many matters have been fixed on. With against my learned senior friend only.
Has to be.
Okay,
very well. So I'll make it on the prayer of learned counsel for the petitioner or party.
Yes, I have no difficulty.
On the
Last
prayer of
week of vacation, I'm entitled to some remission.
On the prayer of learned counsel for the petitioner, let the matter stand adjourned and shall next be listed on June 13, 2023.
Should I bother your lordship?
With what?
My lord, without adjourning, my lord may record that a proposition was from me.
First up, I'll ask you to put that proposition in writing and give to them.
Sure.
Well,
Sure.
It ought to be recorded further that learned counsel for the ED, on instruction, seeks to give a proposal whereby the hearing of the matter can be cut short and the writ petition may be disposed of with certain riders. First up, the ED shall give through counsel such proposition formally to the learned advocate on record for the petitioners
added response.
as well as the added respondents for the latter to consider the same and take instructions thereon. Take instructions on that.
And my lord kept it on 13 June.
13 June.
Deeply obliged.
এটা কি শেষ ম্যাটার ছিল?
Consider as you get. But let today be some effect.
Yes, it has to be.
বাবুরে দুটো চিঠি করে